Good morning, all. This trial is in the matter of CFI 066-2023 and is being held by way of video conference before Justice Rene Lemiere, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Charles Russell Speechley's lead counsel is Mr. Glenn. The defendant is represented on a pro bono basis by Mr. Arvin Lee of Wee Swee To. Thank you, Your Honor.
Thank you. Now, the first item that I have on the trial schedule that the parties sent me is housekeeping matters. Are there any housekeeping matters, Mr. Bull?
No, I don't think so. I have nothing to add.
Mr. Lee?
Just one item, Your Honor, if I may. It's just a formality. I note that in the witness statements for the claimant, there is no line saying that either the opponents are duly authorized to make this statement on behalf of Emirates REIT. So I just need Mr. Bull's confirmation that notwithstanding the language is not in there, all of them are making the witness statements on behalf of, have been authorized by Emirates REIT to make these witness statements on Emirates REIT's behalf.
I'm very sorry. I'm just making sure the camera in our boardroom is switched off. I'm sorry, Mr. Lee. Can you please restate that?
Yes, Mr. Booth. So it's just a formality which I would appreciate your confirmation on. There is no language in the witness statements by this Chloe Sharp as well as Mr. Alan Lipa that they are giving, that they are making the witness statements on behalf, that they are duly authorized by Emirates REIT to make the statements on behalf of Emirates REIT. Can I just have your confirmation that even though the language is not in there, they have been duly authorized by Emirates REIT to do so?
No, they're making the statements as individual persons and giving evidence of their own personal knowledge.
Yes, Mr. Lee, is there something you wanted to raise about that?
Yes, given that this case is between Mr. Kakari and Emirates REIT as such, I think that it is unsafe if they are not authorized by Emirates REIT to give evidence. I do not want a situation where Emirates REIT somehow is not bound by what Mr. Diba and what Ms. Sharp says, especially for Mr. Diba, who is no longer in the employ of Emirates REIT.
Well, Mr. Lee, the way matters work in this court is that a person may give evidence as a witness. They might be called by a party to give evidence, and in some instances their evidence will be given on behalf of a party if there is some particular matter they're saying on behalf of a party, but there's no requirement that a witness gives their evidence on behalf of a party. Indeed, the role of the witness is to give evidence and tell the truth, and that's it. So there's no difficulty in this case.
I am grateful, Your Honor, for that clarification. So I do not see a need to pursue this any further. Thank you.
All right, thank you. Well, in that case, I think we're due that the parties have sent in their written submissions, and the timetable indicates that the claimant should now present its evidence. And Mr. Bull, you've indicated that Mr. Debar is to give evidence first, and perhaps you could start by telling me, how does he pronounce his name?
I just asked him that, myself, Your Honor, just to check. Debar, he said, was fine.
Debar, all right. All right, well, Mr. Debar, I think I can see you. Can you switch your camera on, please, Mr. Debar?
Yeah. Good morning, Your Honor.
Good morning. I'll ask the court officer to, well, first of all, I should ask you, do you wish to take an oath or an affirmation?
An oath, I'm comfortable.
Do you have a Bible with you?
No, I don't have a Bible with me.
In that case, I think you should, in that case, you'll take an affirmation. Are you all comfortable taking an affirmation?
Yes, sir. So
All right. I'll ask the court officer to read out the affirmation and you should follow what she has to say.
Thank you. Can you please confirm your name and occupation for the court's record?
I'm Alain Debar, and I'm a partner at HVS, and I used to be the head of real estate at Emirates REIT.
Thank you. Please repeat after me. I affirm that I will say nothing but the truth.
I affirm that I will say nothing but the truth.
Thank you. Thank you, Your Honor.
Thank you, Mr. Bull. Will you have Mr. Debar verify his witness statements?
Correct. If it helps the court, I will display the section of the bundle and share it on the screen.
Thank you.
Mr. Debar, thank you for joining us today. I have presented on the screen now, I believe you may see the witness statement, which was given by yourself. This document runs from pages 42 to 51 of the bundle. And can you just confirm that that is your signature there on that page 51?
Yeah, yes, it is.
And is there anything that you would like to correct, change, alter, having read this document recently in preparation for this proceeding today in this document?
No, it's all good.
Good. All right. Well, thank you, Your Honor. I will stop sharing the screen and allow you to resume.
All right. Well, thank you. I'm sorry, did you verify, Mr. Debar, that the contents of that statement are true and correct to the best of your knowledge?
Yes, they are.
Yes,
Yeah.
thank you. Well,
Thank you.
I'll invite Mr. Lee to now address some questions to you in cross-examination. Mr. Lee.
I'm obliged, Your Honor. Good morning to you and goodbye, Mr. Debar.
Good morning, Mr. Lee.
I was going to ask the same question about how I pronounce your name, and I hope that Mr. Debar is
exactly,
the right way.
It's fine. I've traveled enough. I'm good with Debar, it's Debar, Alain Debar.
Certainly. Okay. Thank you. Yes. I'd like to start my time with you, Mr. Debar, by asking some questions to understand reporting lines within Equitativa and Emirates REIT, operations and processes, the four letting agents that you named in your witness statement, business thinking and perspectives when it comes to leasing. Please feel free to be as brief or as detailed as you wish when answering my questions. Now, you say that you moved into your last held role in Equitativa in September 2018. When did you start at Equitativa?
I started September 18, yeah, indeed.
That was for that role. Were you in a previous role before? Were you promoted to that role in September 18, or did you join Equitativa only in September 2018?
I joined in 2018 in my previous role as a CEO of a public company, Action Hotels.
I see. Okay, thank you. Mr. Ross Daniel McLaughlin's title looks similar to yours, and he joined at about the same time as your departure. Was Mr. McLaughlin your successor?
Yeah.
I see. Did you play a role in his hiring?
No.
I see. Okay. Within Equitativa, who did you report to?
So I was reporting to the chairman of Equitativa, so Sylvain Vieugeot, and Magali Mouquet, who's the CEO.
I see. The chairman plus the CEO.
Yeah.
I see. Right. And who were your direct reports?
So basically I was head of real estate. So you've got the CEO, the chairman, the CEO, and then you've got a head of real estate, head of finance, head of legal and compliance,
Yes.
and of the development. So each head just reports back into, the C-level.
Right. And who reported to you directly?
So I had a team of property managers, of leasing managers, and asset managers.
I see. When it came to the leasing of shop units, who would you consider to be your right-hand people?
So we have Chloe, I think, was joining us a bit later.
Yes.
So Chloe is a leasing manager.
Yes. Yes.
And I also had property managers that were dealing with the relationship with the tenants.
I see. Okay. And Miss Chloe Sharp joined in August 2020. Am I right?
Yeah, I mean, there was someone before her, right? Yeah. But yeah.
Yes. May I have the name of the person before her? I mean, it's if you recall.
I was just thinking.
Yes.
So we had Sabine. Essentially, in the file, you'd have Sabine, who was the property manager of Index.
Yes. Sabine, right? Sabine.
Sabine, Sabine, yeah. Sabine, I can't remember her
yes,
name.
I see her name on the emails.
Yeah,
yes.
you would have her on some of the emails.
Yes, that's right. Yes. And did Sabine leave Equitativa at around the same time as Miss Sharp joining?
Pretty much, but you had Sabine, and there was another lady you probably have in the emails called Nida. So
right.
Yeah, more or less.
I see. Okay, so roughly the same time. And was there anyone in between Sabine and Chloe Sharp?
I can't recall exactly. You always have people coming in, coming out.
I see. Okay.
Basically, but I was there continuously for 5 years, from 2018 to 2000 to last year.
Yes. So what is your reporting line to Emirates REIT as far as the letting of units in Index Mall is concerned? So I'm asking this because, strictly speaking, your employer is Equitativa rather than Emirates REIT. Hence this question. What is your reporting line to Emirates REIT? So is it you personally reporting to some senior executive in Emirates REIT, or is it your superior in Equitativa who does so?
Yeah, that's actually an interesting question. Emirates REIT is a listed fund, so it's a listed real estate investment trust,
Yes.
listed on Nasdaq Dubai. And as such, Emirates REIT doesn't have any employees on its payroll, right? It's a holding vehicle. Emirates REIT appointed Equitativa as the fund manager and manager of the fund. So Equitativa just runs the business. We report, and then Equitativa reports back to the shareholder on a regular basis and to the regulator. Now, something's important. When I joined Emirates REIT, I have an operational background. I mean, I've got, prior to joining Equitativa, I was 10 years at Hilton and 12 years at Hilton, and then 10 years doing hotel development. So being a hotel guy, I have a very hands-on approach. So not only we were the fund manager, we're actually managing actively the assets, right?
Yes. I see. And so because it's a holding vehicle, was there any human being in Emirates REIT that someone in Equitativa would update and send reports to?
No, so I was responsible for running the business. So we have, we have a system, we have a dashboard. We immediately see all the incident, anything that's not paid, anything that's due.
Right.
So we have dashboards, yeah.
I see. Okay. So essentially, when you speak, it is Emirates REIT speaking, even though your formal employer is called Equitativa.
Yeah, I mean, at all effects, Equitativa is the manager from all the subjects for Emirates REIT, yeah.
Right, I see. Okay, yes. And you mentioned 4 letting agents that you work with: IRE Partners, H&H, CV Richard Ellis, Kaizen.
Yeah.
Yes. Are there any more than 4 of these? You mentioned these in your witness statements. Are there any other letting agents that you work with on Index Mall and Mr. Kakari's units?
Look, we'd work with all the agents, right? So we don't really make I mean, the market has lots of people. There's experts, right? You have a lady, for example, there's a lady we all know here in the IFC. She's called Rasha, but she's a bit of a freelancer. So, for example, we wouldn't do direct. We wouldn't ask her like we did for H&H to do a strategy for a mall, right? But people know her. If you want to rent a shop or an apartment in the IFC, one of the persons you speak to is Russia. So you speak to an array of people, and we were active and we are active in the market. Always talking to all the agents for sure.
Right. But when it came to Ms. Kakari's units, were anyone other than these 4 agents, these 4 letting agents involved?
Sorry, again?
When it came to the leasing of Ms. Kakari's units within Index Mall, did you approach any other letting agents other than these 4? Were they involved?
Yeah, of course. I mean, we're talking to, look, in the world of leasing, a lot of it happens, by talking to people, right? So we were really actively looking because we had to increase the occupancy of the mall, right? So the occupancy of the mall was quite low at the time. And obviously we're engaged, with IRE, we had engaged with Kaizen, we had asked Arbor, we had asked H&H. So everybody in the market, really.
Okay. For these letting agents, were these existing relationships that you took over when you joined Equitativa, or did you engage these letting agents yourself?
No, I took on some existing relationships and I created new ones. For example, Kaizen, at the time I joined in Equitativa, was also the property manager of Index Tower. And then we decided later on to manage it ourselves because, it's more hands-on. CBRE, there was another relationship. But H&H, for example, is a relationship I created. H&H, is a leading, they own a very successful mall, not too far from Index, which is a bit of a reference in the market. So we thought they were very pertinent to what we need to achieve.
I see. So they had their own mall. What's the name of the mall that they ran?
It's called Galleria Mall.
Galleria.
On Wassel Road. So it's a similar type of situation where you have a mall that has no alcohol because Emirates REIT Sharia compliant. So has no alcohol. It's a strip mall and has high-end retail for targeting local families, wealthy people, etc. So, which is the type of clients we wanted to attract into Index.
Understand. I lived in Dubai for half a year and I remember trying to wear alcohol. So I understand what you mean.
So you'd be familiar with that.
Yes. And IRE partners, was it an existing relationship or someone that you got yourself?
Sorry, which one?
IRE partners.
So there was at IRE, there was a lady called Shibon. And Shibon, if I'm not quite sure, but it was an existing relationship. I think she'd worked with Kaizen in the past.
Yes.
And we thought, and she's, as a person, she's a very active person, right? So she's not someone who sits on a chair and relaxes. So she's someone, she's that's going to go and sniff around and look for business and turn every stone.
Understand. So you got IRE partners in. You approached Shibon and essentially you were the originator of the relationship with IRE partners. Is that right?
Yeah, there was a previous relationship with her because people knew her. So I met her through Emirates REIT, right? So I didn't know her before. And then I engaged her, to go and look for tenants first. But there was other people engaged. So it can be H&H, can be IRE, CBRE.
Yes.
So basically it was everybody who's specializes in retail, but not every real estate agent specializes in retail.
Yes, understand. Yes. Business annually, which will give these letting agents in terms of revenue, a ballpark figure is fine.
Sorry again. Sometimes you're echoing. That's why.
Well, is it better now, Mr. Dipa?
Yes, a bit better.
Thank you. Yeah. How much business annually would you give these letting agents in terms of revenue?
No idea. Look, the agents get a percentage of the first year lease, right?
Of first year's lease.
So,
Okay.
so they get a percentage. That's how
Yes.
it works in the market. They bring you business, they get their commission.
Understand. So it's fully commission and no fixed fee, no retainer fee.
So there was a retainer on the H&H mandate, because
Right.
H&H is not typically, it's not only just a broker, it's, it's an investment firm, it's an other owner.
Yes.
And they're like, we don't take mandates, if you give us, we don't take brokerage only. So if you give us a strategy, so we appointed them to write a strategy for the mall, to review, to put the right segmentation, what it should be. And over the time, I think over the 1 year when they worked with us, I think they brought more than 50 visits.
Right. Segmentation meaning market segmentation.
Yeah. Market segmentation, commercial strategy.
Right. Understand. Okay. Yes. And apart from these letting agents, did you have an in-house letting team?
We do with Chloe. When I joined, Emirates REIT was taking the view as an asset manager, like you would see a normal asset manager. Quite quickly after I joined, we had the office in Index Tower, etc. And Index Tower being, the biggest asset of the fund,
Yes.
I said, look, I want to manage it myself. So anyway, so the board approved it. So I started managing Index Tower myself. And obviously from that moment, we had the direct pulse and direct relationship with the clients. And that's when, Chloe joined, etc. We started doing leasing ourselves, which is much closer to your client.
Sorry, when Chloe joined, what about her predecessor? Did you do the same with her predecessor as well? Would you consider her predecessor Sabine to also be your in-house letting team?
Yeah, so there was, Nida previously was doing the leasing. But we reinforce our capabilities when we turn to managing the tower ourselves.
I see. Okay. Yes. Was Miss Kakari's units very near the link with Gate Avenue Mall?
Yeah. So
yes.
So Dubai. The Gate Avenue is basically spinal cord connecting all of the AFC. And I've been in Dubai for 15 years. It took them like a long time to build it. So, but it was coming, the works were under progress. And I think it finally opened in July 2021.
2020, Ms. Chloe Sharp says at paragraph 18 of her witness statement.
Sorry again, work closer to your microphone, you're echoing again.
Yes, so I said, yes, you are right about the June or July, but it's 2020 rather than 2021. So if you look at Ms. Chloe Sharp's witness statement, paragraph 18, she mentions the date of opening.
Yeah.
Yes.
So it's when it opens, and obviously, look, there was a mix of things, but Index Tower, in the period, 2018 to 19, the office building was in the 30% of occupancy. I mean, don't quote the exact number, but approximately 38, I think.
Yes. Okay.
The Gate Avenue wasn't connected. So the Index Mall was not a vibrant, place. Today, Index Mall is buzzing. The office building is full. The Gate Avenue is now a mature, real estate development. People are used to using it. So it's a very different situation today.
Yes.
But it's also something common in Dubai. Where people are, in my personal case, I had a burger shop in an extension of Dubai Mall, right? Which I signed on the back of the plans. It wasn't even leased. So it is something quite common to come in at the early stage of real estate development.
I see. Okay. Yes. And yeah, you said that something, and I also understand that your Emirates REITs Council, Charles Russell speech list is also in the index power, am I right?
Yeah, actually, yeah. And we
Yes.
that's why Emirates REIT, I mean, we went creating the relationship, and I'd
Right.
rather, I was doing the leasing for my clients. So also trying to push my clients to Emirates REIT to work with my clients, right?
Right, understand. Yes. And you've been with Equitativa 2018 September to October 2023. That's 5 years, quite long. Is it right for me to assume that Ms. Kakari was in your tenure in this 5 years? Ms. Kakari was not the first tenant to default on their lease, and you then have to find replacement tenants for other units.
Well, we have a, Emirates REIT has its procedures, right? So when there's a default, you take action.
Yes.
Now, with my background in hospitality, I've always
Yes.
taken the approach to speak to my clients and try to resolve. So it's much better, all the time to sit down and to say, okay, how can I help you? Especially during COVID, etc. We're super flexible. So I remember, meeting, on various instances, saying, okay, fine, you got the amount check. Okay, we're going to replace the checks. We can reset the lease. I mean, we had flexibility, and so they were, but unfortunately we couldn't get anywhere despite various meetings.
Sorry,
I kept
Mr. Diva.
having.
Sorry, let me interrupt you there. I'm not asking about I'm asking about other tenants whom you had to find replacements for. How many other tenants defaulted? And in your 5 years with Equitativa, how many tenants defaulted and you had to look for replacement tenants?
I wouldn't give you I wouldn't give you a number, but I'd say
more than 5.
I mean, depends what you call default, because a default can be a bounce check, right? And you resolve it, but that has to go to courts and be serious cases. Call it, maybe 20.
20.
But it's a pretty big portfolio, right? It's a $1.5 billion portfolio of assets. But there were some high-level cases and some, day-to-day small rent dispute center, claims, right? So
Yes. Okay. Yes. What is your typical process of looking for a replacement tenant? So let's say, I know there's a lot, and you said 20 major defaults. So you have to look for a replacement tenant. Do you have a standard operating process when it comes to looking for replacement tenants?
So you so it would depend, right? But once once your lease, your lease is not going to go anywhere. So you always try to make it work. But once you can't make it work, then you start showing the unit and you look for a client through the property managers or through the brokers.
Internally, are there any written guidelines, internal deadlines as to when you have to start contacting certain people? Are there any guidelines internally for that in order to procure a replacement tenant?
The replacement tenant is, you depend on the market, right?
Right.
For example, in that case, so it depends on the market at that time and of the real estate.
I'm not asking about when you expect new tenants to start coming in. I'm talking about the efforts to reach out to let people know that this unit is now empty. And so, hey, anyone, if you're interested, please come. To do that, you have to contact letting agents, etc.
Yeah, we have a like a database of tenants, brokers, and we send them availability list, right? So pretty much every week or every couple of weeks, we send an Excel table with presentation of the properties, pictures of the properties. And so the market would know what availability we have.
I see. Okay. Yes. You even before you had a very long, illustrious career with Hilton, etc. It sounds like from where you are now, your tenure at Emirates at Equitativa was equally successful. Do you have any success stories, war stories to share with us as to how you managed to get good replacement tenants at the best possible price, at the best possible rentals in these 5 years?
I just wonder, Mr. Lee,
Yes.
we have a relatively limited time, and I just wonder why that is relevant to the questions we're dealing with in this case. A question which begins with an invitation to tell war stories is always makes me a little anxious, and we really need to tie the question in to this particular case.
Yes, I do understand you, and I'm sorry that my language has given rise to such apprehension. I just want to be fair to Mr. To understand what it is that his usual processes are, so that I do not hold him to a standard that may be undue. But if Your Honor wishes me to skip that question, I will stand guided.
Thank you.
Yes. Okay. Mr. Diba, what? For termination of defaulting tenants, what internal deliberations will be made leading up to the decision to terminate?
Again, what was that?
For termination, when you decide to terminate a defaulting tenant, right? What are the internal deliberations within Equitativa that would have to be made? Like, for example, who would have to make the assessments, and who would then have to be consulted, and who then makes the final decision as to whether to terminate?
Okay, so I wasn't the one to make the decision to terminate. So we usually rely on a court order. So I'll go back to legal and I say, can I terminate? Unless they have a termination, or the right steps have been followed to a termination. I don't have a termination. Now, once there's termination, they'll tell me, okay, you can, terminate today. Then I press on a button, the system will calculate everything, close the thing, I got the bill. So it's system generated, there's a prorata of the rent dues, and that's it.
I see. So if legal were to tell you it is possible to terminate, who makes the decision? Are you the one making the decision, or is there someone else making the decision?
Well, to terminate, we usually rely on legal advice.
Yes, but legal advice will tell you, yes, you can, or no, you cannot. Am I right?
I mean, the actual can is actually push on a button, right? But to actually push on the button, you'd go to your legal advice. So I'd go to my lawyer, and I'd say, can I terminate? And then, so we'd have, because in the case, for example, in the case of, imagine there's a restaurant that's fully operational. However, it's closed, it's locked. In some cases, you might need to break the locks, right? So you don't do that unless you have a legal opinion, right? Or a court order.
Yes, Mr. Diba, sorry, I'm sorry if I've not been clear. My question is, my question is quite simple. My question is, after legal says you can, can is one thing. Whether you do something or not is quite another, right? Just because you can do something doesn't mean that you have to do it. So if legal says, yes, you are entitled to terminate tenant X, who makes the decision as to whether tenant X is terminated or not terminated?
I do it right away. I mean, if you go down the route of a termination, the earliest you get the termination, the earliest you can move in with your life, right? So, for example, so I'd be the one pushing legal, saying, hey, can I terminate? So the second they'll say you can terminate, I push on the button.
I see. Okay. And do you have to consult your CEO and chairman? I suppose you do not have to.
No.
No. Okay. Understand. So you're the final decision maker.
Yeah.
Right. Okay. And after you decide to terminate, who would these decisions have to be communicated to apart from the tenant?
The tenant gets so you get there's a notice of termination, and that's it. You put it in the system, and everybody knows.
I see. Okay. Yes. I'm going to ask you a question to understand the business perspective, some business thinking. If, let's say, you lease to a tenant, right, who religiously pays you rent, but this tenant is very laid back about making sure the fit-out works are done, such that the unit looks like a war zone. So you have this unit looking like a war zone, but this tenant is very good for the money and religiously pays you rent. Just that after 3 months, 6 months, the unit still looks like a war zone and it's open to the view to public. Would you, in such a case, consider this tenant to either A, because he's paying rent religiously, so there is no need to terminate this and try to find another tenant who makes the unit more beautiful? Or B, would you consider the fact that this unit is so ugly and spoiling the image of your mall to be so serious that you consider that a ground for termination?
Look, I don't think, look, we rent offices and retail, right? Now, in the context of retail,
yes.
You know, if, you know, the front shop doesn't look suitable, you know, there's a code of conduct, there's a fit out guide, etc. So we go back to the tenant and we say, look, you know, you need to put curtains, you need to put this, right? For example, we currently have a salon, right? Where that salon was located. You know, in certain areas where they're doing the pedicure, you know, we said, you know, you need to put a screen, you need to put a curtain, and they put a curtain. So it's something you manage with the relationship.
Right. Right. Okay. Mr. Bull has something to say, I think.
Yes, I'm just subject to the raising of these hypotheticals. You know, we really should be sticking to this specific mall, this specific premises, and the hypothetical that you proposed was not in any way related to what we had in this case.
Yes, but I think that understanding the business thinking is quite important. Anyway, it's moot because I finished that question, and Mr. Diba has given his views, so I'm happy to move on, Mr. Bull. Now, Mr. Diba, you are here to assist this court with understanding two key issues. Firstly, the steps that were taken by Emirates REIT to find a replacement tenant after Emirates REIT accepted Ms. Kakari's default and terminated the lease. So you'll see in the court papers this phrase called duty of mitigation that relates to this first issue. The second issue is the actual termination date of the lease, which I note you say is 10th of January 2020, and Ms. Kakari says it's either 27th October 2019 or at the latest 10 November 2019. So, Mr. Diba, the first issue, which is mitigation, I want to start by giving you the chance to tell us in your own words, what is the essence of REIT's efforts that makes you able to say that Emirates REIT's efforts that makes you able to say that Emirates REIT has made reasonable efforts to find a replacement tenant for Ms. Kakari's 3 units. So, for example, is there any particular effort stated in your witness statement or Ms. Chloe Sharp's witness statement that you want this court to give particular credit to? Please proceed, Mr. Diba.
I mean, look, I think it's very clear, right, that at all times we used all, you know, possible reasonable efforts to replace the tenant. You know, our objective was to try to rent the unit. Just bear in mind there was about 8 units out of the 32 leased at that time in the mall. So we started the inquiries with Kaizen because Kaizen was the on-site people working with us, but quite quickly we widened it out. So we went to work with other agents. I mean, literally everybody in the market knew, and it was probably within my top 3 priorities to increase the occupancy of Index Mall and Index Tower, because it's there's other things. For example, I thought, you know, the Gate Avenue wasn't open yet, so we worked with DIFC and the building, though, because Index is strata. So we worked with the board and DIFC to get, you know, additional signage approved. So, for example, on the street side, you know, we added some Index signage. On the top of the podium, we added some Index Mall signage for people to invite the people to go, right? We did all the fountains in front of the building. So not only we had lots of leasing actions, we also had a lot of actions to actually improve you know, the whole situation. And we're also looking at putting the right mix of tenants. So for example, we didn't want a mall with, like, you know, we have a mall next door with like 8 hairdressers, right? So, you know, in that case, we wanted, you know, there could be 1 male, 1 female. So it needed to be, so we wanted the right mix. It's a boutique place, right? So we're, you know, we're looking for an Italian restaurant, for a sushi shop, for a pharmacy, convenience. It's not just bear in mind it's not a convenience mall.
Yes.
It is it's not a destination mall. It's like a convenience. So
Right.
it's people who are in the IFC
Yes.
that are.
Oh.
Yeah.
Understand. Yes. So thank you for that, Mr. Diba. On the second issue, which is a termination date, I want to start by giving you a chance to say in your own words why your email of 27th October 2019, which Ms. Kakari relies on as termination by Emirates REIT on that date, should not be construed as termination by Emirates REIT on that date. Yes. Section, if you have the 12 under ahead of the...
Sorry, Your Honour, you're on
that's
mute, but I can... Your Honour, you're on mute.
Your Honour.
Yes, thank you. Sorry, I'm sorry for that.
No.
Mr. Bull, you wanted to object.
Yeah, I think this is a legal question. The point is not a matter for the witness.
That is true. I accept that, and I move on. I just wanted to give Mr. Diba a chance to say anything in his own words without it being a leading question. Yes, I would like to have a few confirmations, Mr. Diba. Let us look at the 15 December 20. I'm going ahead of myself. Please let us look at your witness statement, paragraph 20 and 22.
What page is, Mr. Lee, in the bundle? What page is that?
It is at section B1. And let me give you the exact page. It is 45, page 45, Your Honour.
Yes, and which paragraph of the statement?
Yes, 20 and 22.
All right. Do you have that, Mr. Diba?
No, I'm trying to open my bundle.
Yes. And
Page
you cannot, I'm sure that your
46, I
counsel
think
will
it
be happy
is.
to share screen.
Yeah. Now I've even. No, I can't. Yeah, if you can share the screen better, maybe.
Mr. Wu, would you like to share screen?
I can.
Sorry,
Thank
Mr.
you.
Bull. They're putting you on the grill. See if you can use your system.
Yes.
I can't
Fine.
use the
I will
system.
share the screen to assist the court.
Yes.
This is okay?
Yes. Look at paragraph 20. Oops. Just a moment. Okay. Yes, I'm sorry. Earlier the screen went to a different screen because Monique pressed something different. Paragraph 20, you said, I prepared a letter in response to the 10th November letter to give her one last attempt. This letter was drafted and I signed it on 15th December 2019. Is that correct, Mr. Diba?
Yeah. Basically, so I'd be drafting a letter. I'd send it to legal.
Yes.
Okay. So it's I would sign it and send it only when I get the email back from legal saying okay, you can proceed. Especially when things get. So I'd handle the relationship till it gets legal. From when it gets legal, I wouldn't send anything without the approval of the legal counsel.
Understand. So if we go to paragraph 22, Mr. Wu, it said, you say, I know my letter was dated 15 December 2019 and it sought the defendant to resume the fit-out works by the date. This was a typographical error. To the best of my recollection, I believe the letter was prepared on the basis that would be sent on or around 4th December, but it was not approved internally until 15 December 2019, when it was then printed and sent. Is that correct?
Yeah. Basically, it wasn't sent. So there's a disconnect between the actual letter it was dated and the time it was prepared. Yeah, you have a week.
Understand. So when you say approved internally, you mean approved by legal?
Yeah, I mean, basically, I said, look, here's a draft letter. Can I send it? She probably replied, yeah, go ahead. And
Right, okay.
I didn't change the date.
Understand, yes, because you have already clarified you don't have to clear this with your CEO or chairman. So the only internal approval, I suppose, would then be legal. Is that right?
Yeah.
Understand, yes. Just one more minor confirmation. How do I pronounce the name of the actual replacement tenant that you managed to find? Now, it is a French name, and I know, Mr. Deba, you speak French, Spanish,
Cheveux.
Italian.
Call it cheveux.
Cheveux, okay. Okay, you spell the ultimate replacement tenant for Mr. Kakari's units as CHEVAUX in your witness statement, which will be Chevaux rather than Cheveux, right? But what you have just pronounced is in accord with how the primary documents pronounce it, which is CHEVEUX. So is there any reason why you spelled it as CHEVAUX in your witness statement?
Mr. Bull wanted to object, but I think I'll just see if Mr. Deba can deal with the question. If you can't understand it, Mr. Deba, say so.
Yes.
Yeah, I mean, I'm not sure I understand. Are you asking if it was cheveux or chevaux type of thing?
Yes, because it is, we suppose officially it's Cheveux, VEUX, because that's what the documents say. But in your witness statement, at 7 times, you spelled it as CHEVAUX. I just want a clarification whether
No, so it's no, so it's the same typing or chevaux or the spell check. It's cheveux. I don't know what's written on their trade license, but basically it's Sheikh Amal Maktoum. Yeah, so it's a deal that came in the middle of COVID, September 2021. Yeah.
Understand. So, Mr. Deba will now address the date of termination specifically and will ask you a series of questions. Now, first, let's go to Emirates REIT's position that the termination date is 10th January 2020. That is Emirates REIT's position, am I right?
10th of January 2020 what?
2020 is the date that Emirates REIT says the lease was terminated. Is that right? Yes.
I guess so. I don't know. I don't have the papers in front of me. I think it's.
I'm sorry, it's in your witness statement, Mr. Deba.
Okay, so
all right, Mr. Lee, take him to the paragraph in his witness statement where he says
Your Honor. Certainly, Your Honor. Yes. And you have said, only give a specific paragraph.
Mr. Deba, do you have a copy of the bundle or your witness statement there?
It's actually on the screen here, which I'm trying to open.
Okay.
And when I open it, I'm trying to find
it is in the written submissions of Emirates REIT. Do you have the bundle? Yes, I'm sorry, it's in the written submissions. Yes.
Mr. Lee, that's not Mr. Deba's witness statement then?
No, it is not. Yeah, that was my error. But it is Emirates REIT's position that it is 10th of January 2020.
I was dealing with over 400 tenants, right? So obviously don't have them all in mind, yeah.
Okay, so in your mind, you do not have a fixed position as to what the termination date of the lease, Mr. Kakari's lease is. Do you or do you not have a fixed date in mind?
Mr. Lee, I think this is similar to a previous question where Mr. Bull objected that when or the date on which the lease was, as a matter of law, terminated is a question of law, not fact. You can ask Mr. Deba what he did, what he wrote, what he said.
Yes.
Maybe even, depending on the particular situation, his state of mind might be relevant. But conclusionary questions are not helpful.
Understand, Your Honor. I was asking him to confirm whether that is Emirates REIT's position, rather than what, as a legal matter, he deems the termination date to be. But I do understand that when I asked that question, to come across in a different way. Mr. Deba, do you have the particulars of claim in front of you?
Mr. Bulke, just you mind opening the things? You
The
don't have
particulars
access to
of A2.
What do you want to
Section
ask him,
A2.
Mr. Lee?
Yes. I want to ask him whether he has played a role in the instructions that were given towards the drafting of the particulars of claim. So I need him to look at that.
Well, I think I'll permit you to ask if he was the person who has given instructions to the lawyers, but
Yes.
you can't ask him what the instructions were.
Yes. I would like to ask him, however, I suppose the first question as a matter of precedence would be, did he give any instructions? But I'm not going to ask him what those instructions were, which is, I do appreciate, privileged.
Well, you can ask him if he was the person or one of the people who has instructed the lawyers in relation to this matter, but as you acknowledge, you can't go on and ask him what those instructions were.
Certainly, Your Honor. Yes, actually, I adopt that question as my own. Mr. Diba, did you give instructions towards the particulars of claim?
So I was part of the persons who appointed Charles Russell, as our lawyers.
Right.
Now our legal counsel will be the one reviewing the letter of engagement and
Yes.
the particulars of the claim and all that stuff.
Yes, understand. And of course, at no point did you tell anyone to put 10th January 2020 as the termination date.
Well, Mr. Lee, that's asking
Yes.
the witness what instructions he gave to the lawyers.
Yes, I have come too close to that, Your Honor. Yes, let me try and rephrase that. Your Honor. Mr. Diba, did you ever have 10th of January 2020 as the date in your own mind, as the termination date?
What is the relevance of that, Mr. Lee?
I need to see how much veracity there is in the 10th of January termination date. And I think it's a fair question to ask that of Mr. Diba because he's already confirmed he's hands-on and he's the ultimate decision maker after clearing with legal, of course, when it comes to termination.
You can ask him what he did. You can ask him what decisions he made.
Yeah.
But you can't go asking him what he thinks is the legal position.
I do understand that, and I stand guided. I will move
You can
on
ask
to,
him if he made a decision to do something or if he did something.
Yes, Your Honor, I thank you for this guidance, which I am very grateful for. Mr. Diba, did you ever get Emirates REIT or send a letter to Equitativa to Ms. Kakari saying that 10th January 2020 was the termination date? Yes or no?
I cannot remember if I sent her, notice with that exact date. But for Emirates REIT, this would be a technical question, right? So basically the legal counsel would get back to us and say, look, the termination date is, if I have an email, I'm sure at some point we would have sent a notice to terminate the lease, right? I would think.
Yes, let me help you. For evidence, there is no such indication that such notification was ever sent to Ms. Kakari.
Okay. I also remember there was
Yes,
another.
Mr. Wait a minute, Mr. Diba. Yes, Mr. Bull.
I would just note that it is already been concluded in the immediate judgment application that the lease was terminated. And so, I don't know where these questions are going.
Well, I'll permit it within the limits we've struck because it's going to the question of the date on which it was terminated. And I permit Mr. Lee to ask whether Mr. Diba sent or knows whether a notice describing itself as a notice of termination was sent. And I think he's effectively said he doesn't know.
Yes. Yes, thank you, Your Honor. Yes.
If I'm not mistaken, there was an attempted, process, and at some point, Charles Russell, indicated. I mean, we got some information saying, look.
Be careful, Mr. Deba. I do not want you telling us what was the advice given to you by Charles Russell's speech, please. That is pretty. Yes.
Okay.
Yes. Be careful with your answer. Yes.
I mean, I don't have it in mind. Remember, it's 5 years ago, right? 4 years ago.
Understand.
But we wouldn't terminate the lease without, legal advice, especially when it's going legal.
Yes, Mr. Deba, if no notice from Emirates REIT or Equitas EVA was given to Ms. Kakari, that 10th January 2020 was the termination date, is it reasonable for Ms. Kakari to know that 10th January 2020 was the termination date?
I'm sorry, could you just explain the relevance of that?
Yes, I just need to test the veracity of the 10th January date. I need to know what was given to Ms. Kakari in order to let her know that that was a termination date.
Well, you can ask, Mr. Lee, you can ask Mr. Deba whether he sent any communications to Ms. Kakari or didn't send any communications to her. But the date on which the lease expired or was terminated is a legal question which must be determined after determining all the facts, all the things that go towards deciding on what date it was terminated. So you can ask Mr. Deba about those things, but not about on what date as a matter of law the lease was terminated, because that's a question of law.
Yes, I'm sorry, Your Honour, that it had come across that way. What I was asking was whether it is reasonable to expect, for any person to expect, not having been given notice that there was a date. All I need was an answer as to the reasonableness of the belief rather than what the date is.
No, well, I won't allow that, Mr. Lee.
Your Honour, I stand guided, yes. And I would now move on to my next question. Is it your position that the 15th December 2019 letter was to give Ms. Kakari an additional grace period for performance?
Look, I think our position with all our clients has always been to be flexible. So my approach was to meet with the client saying, look, I mean, I understood the building wasn't full, etc. How can we help you? Let us give you more time. Let's reschedule the lease. Let's reset the lease. I mean, there's numerous examples where, we canceled the lease. We did amendments to the leases, etc. And we've done it. At some point, we just stopped getting responses to our letters and more bounce checks. So at some point,
Understand. So flexibility is important in your dealings with tenants.
So
am I right? Flexibility is important in your dealings with tenants in such a case. Am I right to hear you say that?
I mean, I'm actively involved. Yeah, I was actively involved in all the dealings, especially when it's, it was getting to important properties, right? Index was.
Understand. But before you sent the letter dated 15 December 2019, Emirates REIT had already done two things. The first was done by you personally, which is to send the 27th October 2019 email mentioning termination. The second thing was that Emirates REIT had already commenced criminal proceedings in the criminal courts of Municipal Dubai against Ms. Kakari by latest 22nd October 2019. And if you need evidence, it's at section L2 of your bundle, L2 page 832. Do you consider the institution of criminal action proceedings and the sending of an email saying you're going to send this to legal with a view to termination to be the exercise of flexibility?
What's the relevance of that, Mr. Lee?
Because
again, the question, in the end, what I have to decide is on what date was the lease terminated. To decide that, I have to know what happened, what
Yes.
communications there were, what was
Yes.
said. Now, if you're questioning Mr. DeBar's credit and you want to question him about whether he is flexible as he says he was, then I would allow those questions. But I haven't understood you've challenged his credit.
Right. Yes. Understand, Your Honour. And the next question that
If the question is going to credit, tell me. But if it's said to be relevant, then I can't see its relevance.
Yes, I do understand that. There will be a question on credit subsequently, and I'll come to that and I'll let Your Honour to that. And I'm very sorry that you correct me, because my first boss in arbitration was Michael Huang, who was very particular about questions not to ask in cross-examination. And now I have to tell him that I've been corrected many times on this occasion. But I do understand where Your Honour is coming from, and I'm going to try to improve my questions going forward.
Okay.
Mr. Diba, let's take a detailed look at the 15 December 2019.
Do you know what page is it in the bundle, Mr. Lee?
Yes, it is at, sorry, I got it in an earlier point in my, the 15 December 2019. Yeah.
Maybe, please, if I can just maybe attend Mr. Debar for one moment to assist the bundle setup on his computer.
Well, that would be helpful.
Yes.
I mean,
okay.
Yeah,
one moment. I'll just pop over and just make sure it's displaying correctly.
Yes, I think that's a good idea, Mr. Bull, please.
Yes.
I just put the mic off 1 second.
Yes. Please let us know when you're ready, Mr. Diba. So, Mr. Bull, it is page 57 of the bundle.
Oh my God.
What page?
57, Your Honour.
Sorry. And here.
Yes. Do you have that in front of you, Mr. Diba? Page 57.
It's opening.
Okay.
Yeah, here's
Mr.
the
Bull,
letter.
please feel free to stay until the letter is on. I am very sure that it's perfectly fine for you to be with Mr. Diba there.
I got it
Do you
now.
have the letter now? Your Honour, do you have the letter in front of you?
We'll just wait for Mr. Bull to get back to his desk.
Yes.
Thank you, Your Honour.
All right. Yes. Now, Mr. Lee, Mr. DeBar has the letter. What do you want to ask him about it?
Thank you. Is there anything in that letter that gives you the basis to say, to give anyone the basis to say that 10th January 2020 is the termination date? So let me break this down, this question. Let's look at the last paragraph. Do you see any dates there stating 10th January 2019?
I'm sorry, you're referring to the last paragraph on page 57?
Yes.
Is that the paragraph that begins, notwithstanding the above, Emirates REIT is also keen to find an amicable solution to this matter. However, given the bounced payments, non-adherence to the terms of the lease, the landlord requires at a minimum, and then sets out 4 points. Is that what you're directing his attention to?
Precisely, Your Honour, and even more specifically, the 4 points.
Should be
all right, and what do you want to ask him about then?
Yes, Mr. Diba, you drafted the letter. Did you have a 10th January 2020 deadline in mind?
No.
When you drafted the letter?
No, look, so we don't anticipate the termination deadline, in advance. So, but you also, you put milestones. So when you write to someone, you say, look, by that date, you need to have, cleared your payments. You need to have a license. You need things to move forward, right?
Understand, yes. But there is no specific, when you drafted the letter, you did not have 10th of January in mind, 10th of January 2020 in mind at all. Do you confirm that?
No.
That specific date?
No.
Yes. Okay. I now move on. It seems to so you gave Ms. Kakari a deadline of 15 December 2019 to resume the fit-out works. That's item number 3. Yes. And so at paragraph 22 of your witness statement, which I got you to read earlier and to confirm, you said that you also you mentioned that there was a typographical error, and it was not until 15 December that it was sent. Is that right?
Yeah. So basically,
Yes.
you've got 10 days difference between the two. So
Yes.
accordingly, the works
Yes.
fit out. Should
Yes.
start no later than if it was sent on the 15th, would have been 1 week after. But in real life, if it's a you give a phone call and you say, look, we're starting 1 week later. So we're flexible all along the way. It's really about, and here again in the letter, we're talking about finding an amicable solution. However, considering the bounce payments, we require that you complete your approvals, that you start your fit out works, that you start paying the rent from September, which is due. So that's all factual, right? So notwithstanding the dates, there might be a typo on the date. Remember, it was written 4th December, and it was ultimately only sent on the 15th. So just everything, you can roll everything by a week, doesn't change the merits of the case, I think.
Okay, but you have just also said at paragraph 20 and 22 of the witness statement that it was sent on the 15th of December. So if it was sent on the 15th of December and Ms. Kakari receives it early as 15th of December, how do you expect her to comply with item number 3?
This is what I just told you. Item number 3. So it was 15th of December when the letter was written on the 4th. So basically what we're saying here, it's a letter, it's not a legal notice. But what we're saying here, look, you've got 1 week to get started with the works, please move on, right? So it's, remember, you're still amicable at this stage. So we're saying, basically we're saying 2 things. Give us a schedule of work, complete your approval process, start your fit out works, and pay me the rent that you owe me. That's simple as that.
I do understand that, what you're saying, but I'm now focusing very narrowly on this point. Mr. Deba, it'd be helpful if you confine your answers to that. If you really were sincere in giving Ms.
Just a minute, please, Mr. Lee. Just a minute, please. Yes. Mr. Bull, you're objecting, but I confess I don't know what the question is yet.
You're on mute.
You're on mute, Mr. Bull.
Mr. Bull, you're on mute.
Apologies. My understanding is that this question is going back to the paragraph where we've explained with quite specificity that there was a delay in sending the letter, and that the typographical error we're talking about is this exact date of the 15th December. It wasn't intended when the letter was sent that the defendant would resume her works that afternoon. It was intended and drafted on the 4th. Sat with legal or whatever the internal process was, and then it was said that this is...
Yes, all right. What is your question, Mr. Lee?
Yes, thank you, Your Honor. Yes, I do note that you have mentioned the concept of a typographical error, which you might want to correct. If you really were sincere in giving Ms. Kakari this grace period, you have taken pains to correct this typographical error of the 15th December, right? When you sent it out, you would have given more time. But the fact is that you did not correct on item number 3, this 15th December date. You did not correct it. And I put it to you that because of this, there was no sincerity in giving Ms. Kakari a grace period. Do you agree or disagree, Mr. Deba?
Totally disagree, Mr. Lee. I think this is totally unacceptable. But basically, remember we met the client on various instances. Remember we pushed it. Remember you already had 4 bounce checks. Remember, we'd given a previous time to resume. the submittals weren't complete. There was no approval. So on my side,
what happened in the past, Mr. Diba? I'm talking about just this letter. Confine
this
yourself
letter.
to this letter. And item number
I
3.
mean, basically, the letter got back from legal, probably an email just saying, yeah, go ahead. You know, I just put it in Word on a letterhead and boom.
Yes.
Honestly, it also indicates that at that time, I also had, you know, better fish to fry than just to take care of that one client in a portfolio of, you know, 500 plus clients. So basically, you just put the letter and you just send it, right? Probably didn't. So yeah, a typo error, but we're also talking about an amicable solution, right? So if there's an amicable solution, so we wouldn't have a typo error in a legal notice, right? Now in a letter saying what our intentions are, you know, why not? So basically we're saying, look, hey, my friend, you know, please finish, give me a schedule, get your approval straight, start immediately and pay me your due rent. Basically, that's all this letter says. It's not saying we're going to terminate. It's not saying anything. It doesn't have any thoughts in mind. It's just saying, I think you should read again, Mr. Lee. It's just talking about finding an amicable solution to the matter, which is the spirit of the letter.
Understand. Actually, Mr. Diba, there was a time lag between the time my client received the letter and the 15 December deadline. And Your Honor, I did mention earlier, there's a question that will go to credit, and I'm foreshadowing it here. This is it. My client's instructions to me last night, and she's got the email, are that your colleague, Ms. Stacey Brooks, actually sent the 15 December letter.
I'm sorry, I'm having, just a minute, please. I must say, Mr. Lee, I'm having a little difficulty hearing you. Is the microphone close to you?
I'm putting it even closer now. Can you hear me?
Better.
That's, I think, a little better. Could you start again?
Thank you. Certainly, Your Honor. Yes, Mr.
Before
Bull
we
has something to say.
Yes. Yes, Mr. Bull.
My learned friend has referred to a letter, an email that has not been included in the bundle, hasn't been exhibited, and I have not received this document. So you're saying she provided it to you last night?
Yes.
We object to this being added or referred to at this point.
Mr. Bull, if you finish here to the end, you can make your submissions to the judge because I will
Well,
make
let's
an oral
have your
application.
question. Let's have your question, Mr. DeBar. Don't answer it until I have told you to.
Yes, thank you.
What is your
Your
question, Mr. Lee?
Your Honor, yes. My client's instructions to me yesterday were that Mr. DeBar's colleague, Ms. Stacey Brooks, actually sent the 15th December 2019 letter to my client's lawyers on the 5th of December, at 3:25 p.m. And my clients then had this letter. It was sent to my client's lawyers, and my client's lawyers then forwarded it on the 9th of December 2019. I will be asking Your Honor for permission for this email to be adduced, indicating exactly what I said. And this came...
Now, wait a minute. This is some copy of the emailed letter, an email containing the letter of 15 December that was emailed on the 5th of December. Is that what you're talking about?
Precisely, Your Honor. It was Mr. DeBar's colleague in Equitativa, Ms. Stacey Brooks, who herself sent it to my client's lawyers, Municipal Dubai lawyers, on the 5th of December. But Mr. DeBar said that he needed clearance time to consult with legal. That's why there was a lag time.
Well, let's take this a bit at a time, Mr. Lee.
Yes. Yes.
So what you are saying, if I understand you correctly, is that the letter of the letter which is dated 15 December, you are saying that that letter was sent by somebody else, or a copy of it, to your client or your client's lawyers on December the 5th. Is that what you're saying?
Yes. Would it assist Your Honor if I were to get that email put up on the screen for Your Honor to see?
Well, first of all, before you do that, ask Mr. DeBar if he knows. And you ask him, you mentioned, I think it was Stacey Brooks or something. So ask him if he knows who she is. Ask him if he knows whether she sent a copy of this letter to somebody. Ask him if he knows whether she sent it to who she sent it to. Ask him if he knows what date. That's the way you go about it.
Yes, Mr. Diba, do you have any knowledge of Miss Stacey Brooks sending that letter via email?
Well,
My
can we
client's
start? Can we
lawyers?
start with Mr. Lee?
Yes.
Mr. DeBar, ask Mr. Barr if he knows who Stacey Brooks is.
Yes, Mr. Diba, do you know who Stacey Brooks is? I know that she has an equitativa name in her email domain.
Yeah, I mean, she was in my team, so working. So I had Nida, I had Stacy. I mean,
Yes.
there's lots of people at Equitativa, right? So Stacy
Yes.
was the leasing manager with Nida.
Yes.
Yeah.
Yes, I do understand. And do you have knowledge of Miss Stacey Brooks sending that letter dated 15 December 2019 to Miss Kakari's lawyers on the 5th of December 2019? Do you have knowledge of that?
Look, I wouldn't, babysit, my team, but actually, you know what? It's beside the fact that I don't know how relevant it is in the case where it's been sent on the 4th or the 15th, considering, it's an amicable letter. But personally, I'd be more satisfied of what I did if, the letters was meant to be dated 4th of December. Ultimately, someone wrote 1/5 instead of 5 of December and sent it on the 5th. It makes me feel better than sitting on a legal letter on a legal desk for a week. So whether I can actually remember what happened, no. In this 10-day gap, but it actually feels much better if it actually went out one day after the date, which then in that case means that your argument number 3, 15th of December then was valid. But in any case, it's all pretty relevant because it's amicable. We're talking about amicable solution. We're saying, give me a schedule, complete your approval, start your fit out work, and pay me the money you owe me. So yeah.
Mr. Diba, yes, I would appreciate if you confine your answers to the question. It's about the 8th time I'm hearing you say, we are very keen on amicable settlements. Yes, I know that's your position. You have made that very clear already. And I'm going to say to you that when the email is shown, it will show you as being one of the persons in copy. When Miss Stacey Brooks sent it, you were in copy. Yes.
All right, Mr. Lee, if you want, you can show him the email. You can put it up on the screen if you want.
Thank you, Your Honor. Yes, I'm having it put up right now.
Yeah, so you have, okay, sorry.
Yes. I'm going to ask my assistant, firstly, to open the PDF file on the top left-hand corner, and you'd say it's VK Legal 4th December 2019. Monique, please open it. And I'm going to ask for that to be shared as well. You have to expressly share that as well. You don't have to. Okay. Yes, do you see the letter on your screen now, Mr. Diba? 15 December 2019 letter.
Yeah.
Yes. So this is just to show that the attachment does contain this exact letter that we are now discussing. Scroll down, Monique, just to make sure there's no doubt. Scroll down all the way to the 3 items. So, Mr. Diba, I'm happy that you say that now you have fulfilled the spirit of item 3 by giving Ms. Kakari some time. But you have now run into a different problem, which means that you have negated paragraphs 20 and 22 of your own witness statement. Would you please read paragraphs 20 and 22 of your witness statement?
What page are they? You can take the email down off the screen now, Mr. Lee.
Yes, Your Honor, thank you.
And tell us now what page in the
B1,
bundle is the witness
yes.
statement.
Yes, Your Honor. B1,
Page
page 45. I'm sorry, more specifically, it's paragraph 22, that one. So that's page 46. Page 46. Are you there, Mr. Deepa?
Yeah, yeah.
At page 46? Your Honor, are you at page 46, paragraph 22?
Yes.
Yes. And the final sentence of paragraph 22 says, but it was not approved internally until 15 December 2019, when it was then printed and sent. Do you still maintain that paragraph 22 is correct, Mr. Deepa?
Look, if you read again, Mr. Lee, there was a typographical error to the best of my recollection. Obviously, 4 years later, you don't recall the exact dates. So now when I look at the files and the evidence that of the case, you look at the letter and you say, damn, it's written, 15th of December, but it should have been the 4th. So honestly, your argument doesn't really make my day, Mr. Lee.
Mr. Deepa, no one here actually really would care about what my argument, if you can call it, makes your day.
Yeah.
But the thing is that I'm not arguing with you. I'm asking you questions, and you're here to answer them, Mr. Deepa.
Yeah.
Right?
Look,
I haven't even made my arguments yet. I have no idea why you're saying that's an argument.
All right,
Just look at
Mr.
paragraph
Lee,
22.
could you confine yourself to asking some questions at this stage?
Yes. Look at paragraph 22, and it says it was not approved internally until 15 December 2019, when it was then printed and sent. Mr. Deepa, do you wish to correct that?
No, I'm saying to the best of my recollection. So, for me, if you show me a letter that was prepared on the 4th, sent on the 15th, where else could it, 4 years later, I'll tell you, damn, okay, if I didn't send it, it wasn't in my outbox either. If I didn't send it, what could have happened? Well, what could have happened is that it was sitting for an approval.
And
it wouldn't be sitting on my desk. Yeah.
And then that's the question. If on a document as important as the 15th of December letter that you are seeking to rely on, there's an error, can you say with certainty that there's no other errors in the rest of your witness statement?
Absolutely not. And I wouldn't call it an important letter. I would say, we're talking about, amicable solution. So basically, we're just writing, again, please finish your fit out, please pay what you owe us, blah, blah, blah. So, yeah.
So, Mr. Deepa, just one question again, and you've not answered my question. Do you wish for the last sentence of paragraph 22 to remain there? Is that correct?
I wish that you please read my full sentence, which starts by "to the best of my recollection."
Yes, but it's very important, Mr. Deepa. Number one, there is a big gap of time. And number two, during this big gap of time, you said you were consulting internally, getting internal approvals, which is legal. Now, you also said yourself that the letter was drafted on the 4th or the 5th, and now we have established that it was sent out almost immediately, which means that you did not consult legal. Did you, or am I right to say that?
No, I would have consulted for sure. Now,
how do you find the time to consult it? Because now it's been sent out even before the lag time is there.
Because there's two ways to, if you ask me 4 years later to recollect if there's a 10-day difference, I will tell you, okay, it was gone for approval, right? Now, there's two ways to get things approved. The equitative, everybody sits on the same floor, right? So I could have also printed the letter, gone to the legal counsel, say, what do you think of that reply? She'd have a look. She'd say, okay, go send it. So, can't recall.
Understand.
Honestly, yeah, it doesn't, I'm not sure how relevant it is, but...
I've got a question on that. Now, this is presumably in the internal record still of Emirates REIT, which is why you could exhibit the 15th December letter. The email was copied to you, right? How did you prepare your witness statement? I'm aware that you're now not within Emirates REIT's employment, so you don't have ready access. but did you look through all primary documents before committing pen to paper and saying what you did? Did you or did you not look through your primary documents first?
Yes, Mr. Bull.
I do have to note that this letter should have been produced by the defendant before the witness statements were prepared. So if she had produced it, it would have assisted the preparation of that witness statement. And that was due back in February of this year.
Well, that's true, but we've gone on beyond that. I also want to note, Mr. Lee, that you're scheduled to have 90 minutes for this cross-examination. By my calculations, I think you have about another 10 minutes to go. So I think you should use it wisely.
Yes, I may need to go on more because Mr. Deba, I gave Mr. Deba the luxury of time to expound on his answers, which, well, and we have heard what he has said. But Ms. Your Honor, I was then guided by you as to when and as to how this is going to be conducted. Now, Mr. Deba, 27th October 2019 was the actual termination date, and that is my client's position. Do you dispute 27th October 2019 as the actual termination date?
Yeah, just a minute, please, Mr. Deba. Again, we're running into the problem that that's a legal question, Mr. Lee. You can ask Mr. Deba whether he did something, whether he knows something, but to ask him what, as a matter of law, was the termination date is a question of law, not a question of fact.
Yes,
but you can ask him, again, ask him what he did, what he said, what he wrote, what he received. You can ask him questions like that.
Your Honor, yes. Mr. Deba, your email of 27 October 2019 mentioned you were passing the matter over to legal. Agree or disagree?
I think that's what's written in my, well, let me open the bundle, but I believe that's what's written in the page, sorry.
Yes, that's right. And that is...
Mr. Lee, can you please provide the page number?
57.
B2, B2.
Yep, section B2.
Page number.
Page 53.
53.
Yes, 53. Yes, Mr. Deba, are you on that?
Yeah.
Yes.
So this matter's been moved. So we will get to inform you that we're not in a position to allow the works to continue pending the payment of the dues and reasonable assurance that you're in a position to honor the terms of the lease.
Yes, that's right. And you also mentioned...
Sorry, but we have requested you a meeting, which you have ignored.
Yes.
And subsequently filed a case for the bounce check, which is normal procedure in Dubai, by the way. This matters be moved to our legal department, and we've commenced legal action to terminate the lease, evict, and recover the fit-out contributions. So
thank you for confirming the text. Yes.
Yeah.
Now,
so
what's your question, Mr. Lee?
Yes, by 27th of October 2019, you were sufficiently worried about Ms. Kakari's ability to perform. By perform, I mean pay the rent, that you had in mind terminating the lease. Agree or disagree?
Yeah, of course. I mean, there's been many discussions in the past, I believe. And at some point, we're saying, look, at that point, I thought, okay, fine, this is not going to go anywhere.
Yes. Were you worried or were you not worried about Ms. Kakari's ability to pay?
Look, at that point, I mean, I can't remember my feelings at that point, but I would have thought for writing that, I was like, she's not going to, we've heard the music many times, they're not going to comply with the lease. So, you know what, we've taken it to legal and we'll commence legal action.
Yes. So, and you sent the Ms. Kakari the termination email on 27 October 2019. In early November, you say that you asked Kaizen to find a new tenant for Mr. Kakari's units, because by then you believe that Mr. Kakari was unlikely to pay what she owed and unlikely to be able to complete the works on the premises. And if you need a refresher of the memory on that, please look at section B1, which is your witness statement, paragraph, page 45, paragraph 19.
Yeah, so yeah. I mean, that's business as usual for Emirates REIT, right? So we look at, in view that they were, unlikely going to pay the dues and being able to, look, my job was to make sure my units are leased, right? So losing a client is never good news. So, meet with the property manager and tell them, let's start finding a new tenant.
Yes.
So plan B, right? Contingencies. We always have contingencies.
Yes. Okay. I now put it to you, Mr. Diba, that Ms. Kakari's August 2019 check bouncing led you and Emirates REIT to form the view that Ms. Kakari could not perform her payment obligations under the lease. And I think that you have just, well, even though you gave a long answer, you did not disagree with that. Am I right to say that you agree with that?
That she could not perform. I mean, we also had, I can't remember at what time, but I remember, we met also face to face, right? There was not only just letters. And she couldn't pay, and I need more time, and I can't pay. So there was always something.
Yes.
So I was like, the opinion, look, it's not going to happen.
Yes.
By October, November, by Q4 2019, I was like of the opinion, well, unfortunately, it's not going to be able to happen.
Okay.
Remember,
Mr. Ba, you have not answered the question. Do you agree or disagree? Can you just state for the record whether you agree or disagree?
Agree to what statement exactly?
That Ms. Kakari's August 2019 check bouncing led you and Emirates REIT to form the view that Ms. Kakari could not perform her payment obligations under the lease because her August 2019 check bounced. Do you agree or disagree?
I disagree because the way you're formulating your statement means because of that check bouncing, we think she not perform her obligations. Our view of her not performing obligations is the fact that, she'd taken the fit-out money, nothing had happened on the site, she'd bounced 3 checks, there was no permit, you know what I mean? So there was like 6, 7 elements for us to form the view that she wasn't going to.
I understand. That means, Mr. Diba, you are saying that by this 27th October 2019, you were not worried about Ms. Kakari being unable to pay. Is that what you're saying?
27, sorry, which one?
27 August 2019.
Yes, Mr. Bull, what is it?
I believe we are rehashing matters that have been resolved in the immediate judgment application.
I think it might be quicker if I let Mr. Lee ask this question and we get it answered.
Okay.
Yes, and Mr. Diba, it will help if you just say agree or disagree first, followed by your explanation.
What, are you talking what, 27th of October or 27th of August?
27th of October.
Okay, so
were you worried or not worried about Ms. Kakari's ability to pay?
What are you asking? Was he worried or not worried about what?
Ms. Kakari's ability to pay the rent. Because, Your Honor, it is common ground.
What's the relevance about whether he's worried or not worried about her ability to pay the rent?
Yes, then that would go towards the reason why that 27th October email was written. If Mr. Diba can credibly prove that there is no reason for him to be worried, then we can then, in fairness, say that the 27th October email was not a termination. But
no, Mr.
Yes.
Lee, I'm not going to ask you, I'm not going to permit you to ask Mr. Diba if he thought at this date that Ms. Kakari may or may not have the capacity to pay. You can ask him what he did. You can ask him what he said, what he wrote, what he received.
Yes. Your Honor, yes. I wanted to give Mr. Diba every chance to explain. I actually have enough. on the primary documents to make submissions. I just want to give him a chance to explain. I now
right.
move on to Mr. Diba. Now, by 27th October, Emirates REIT had commenced criminal proceedings against Mr. Kakari. Now, I think we saw earlier, it was the 22nd of October that criminal proceedings were commenced. Mr. Diba, I put it to you that any tenant, when faced with something as relationship killing as the institution of criminal proceedings, can reasonably conclude that the landlord wants the commercial relationship with a tenant to end. Do you agree or disagree?
It's not relevant, Mr. Lee.
Okay, Your Honor, I stand guided. I now move on to the 10th November 2019 date.
And Mr. Lee, by my calculations, you've now had your 90 minutes. I'll give you a few minutes to wrap up, but you really need now to concentrate on the most relevant questions and bring your cross-examination to a close.
Your Honor, yes. Mr. Diba, would you please look at section A4, page 36 of the bundle? Page 36, paragraph 26, F and H.
Paragraph 26, which subparagraph?
F, starting from F to H. Mr. Bull, yes.
Yes, these are the pleadings. This is not something for Mr. Diba to provide any evidence on.
The pleadings do mention facts, Mr.
Well,
Bull.
This is a paragraph that says, after 10 November 2019, the defendant made no effort to remedy the defaults it had been notified of. Is that the paragraph?
Yes, that's right. And then if you were
what
to
do you
go
want
down,
to ask Mr.
paragraph,
Diba? Sorry, is
yes.
this Mr. Diba's witness statement?
No.
No, it's a pleading. But if you look
I
at
see.
section G,
All
yes.
right, well, you've got a statement there. What do you want to ask Mr. Diba about it?
Yes, Mr. Diba, look at subparagraph G. It says the value of the fit-out works completed on site were de minimis, and nothing of value had been left by the defendant or the fit-out contractor at the premises. Is that something that you have personal knowledge of?
I mean, I saw it, and I mean, basically, just as a bit of background to that, when Emirates REIT did the lease, Emirates REIT accepted to contribute a fit out of up to 1 million dirhams to the works.
Yes.
When I really got involved is when so they had drawn down 750-ish. And then I got a request to sign a check for another 250. And I'm a hands-on boy, and I decided to go down. I mean, I've got my office in the building. I said, okay. I told my guys, okay, I want to see the fit out. So I go down to the shop, and there was literally nothing. And I said, well, excuse me, where's the 750,000 dirhams we put in? Sorry, Mr. Bull.
Well, I think you've got an answer, Mr. Lee.
Yes, Mr. Diba.
I would just,
Yes,
we are
Mr.
talking at a different time period here. Mr. Diba is referring to the period. Sorry, I won't interfere with what he's saying, but I think we do need to focus on the period of termination.
Well, I'm trying to tell Mr. Lee, you're already out of time. I'm going to give you some more time, but you've really got to focus on the relevant questions now.
So actually on termination date, that is my final topic.
Okay.
Because the 7th,
So let's get on with it.
Yes, 10th of November is the final date. Now, so subparagraph F is something that you have personal knowledge of. And was it on or around 10th of November 2019 that you had personal knowledge of the matters stated at subparagraph F?
Well, so paragraph F says, after 10 November 2019, the defendant made no effort to remedy the defaults it had been notified of. Now, what is it you want to ask him, whether he's got personal knowledge of?
I apologize.
Is it
Subparagraph G.
after 10 November, the defendant made no attempt to remedy defaults? Is that what you want to ask him?
No, I'm sorry. It's subparagraph G, rather than subparagraph F.
Sorry, which paragraph?
G.
E. The defendant had
G for golf.
effectively abandoned the premises.
No, Your Honor. G for golf.
G for golf.
Yes.
The value of the fit-out completed on site were de minimis, and nothing of value had been left by the defendant or the fit-out contractor at the premises. Well, in light of what Mr. Bull said a moment ago, perhaps you better fix a time. If you're asking him about whether he knows or saw fit-out and value it on the premises, you better fix a time so that he
It's
can
entirely so, Your
orient
Honor.
himself.
And that's why my question now is, was that a state of matters that you had personal knowledge of by the 10th of November 2019?
Mr. Lee, I believe in the bundle you also have, because we have engineers, right? So we used to have technical reports with pictures of the sites, and I'm pretty sure Mr. Bull's got a technical report somewhere in the bundle with pictures of the site where.
Mr. Diba, do you or do you not on that date have knowledge, yes or no?
I had more than 2,000 units under management. So obviously, I cannot recall specifically. However, I can recall the journal. So obviously at that date, I cannot recall specifically. All I can tell you, there was a bit of marking of block work and 4 pipes in the ceiling.
I see. So there is no way you can support paragraph G. Is that what you're saying?
Well, it's not a question whether he can support it. Just ask him what he knows, what he saw, and then you can argue later about whether it supports it or not.
Yes. Mr. Diba, on the 10th of November 2019, or thereabouts, give or take, 10th of November, did you have personal knowledge that the value of the fit-out works completed on-site, what the meaning is, on-site meaning Ms. Kakari's units, and nothing of value had been left by Ms. Kakari or the fit-out contractor at the premises?
Yeah, for sure. There was nothing of value. I mean, I can remember that.
Yes.
But again, if you refer to the bundle, you'll have the pictures.
Yes, and you know that because you re-entered the premises. Am I right to say that?
Sorry?
You've got to be careful here now, Mr.
Yes.
Lee. I suspect you're using the word re-enter as a legal term. I think you're going to have to ask him what he actually did.
Yes, I stand guided, Your Honor. Mr. Diba, I am suggesting to you that you know that nothing of value had been left by the defendant on the premises because you actually physically went into that unit on the 10th of November and saw that for yourself, or your agent saw that for your employee saw that for him or herself and reported that to you. Agree or disagree?
I mean, if you had been on site, Mr. Lee, Index Mall is all glass, so you don't need to enter a unit to see what's going on, first of all. And second of all, as part of the procedures of fit out, there's an engineer appointed by the building that reports. So in the bundle, as I mentioned, we've got a very informed detail, showing the status of each shop and each fit out.
Yes. Do you deny
and that
of the
consultant
10th of November?
Hold on. And that consultant is actually engaged by the tenants as part of the fit-out fee that they pay.
Okay. Just on the very issue of whether you had physically entered, do you admit or deny that by the 10th of November 2019, you or your employees had actually physically gone into Mr. Kakari's premises?
Yes, Mr. Bull?
The right to enter the premises is a matter that has to be examined under the lease. And this is during the fit-out period where I believe they did have, the landlord does have access, but that's just not something that I think is even relevant to these proceedings.
Well, it might not be, but I think if the question is simply, you're not asking Mr. Lee as a matter of law whether it was a re-entry, you're not asking whether they were permitted to do it, you're asking whether Mr. Diba himself physically walked on to the leased lot, although I think he said before there was glass across the front that he looked through, but you can ask him whether or not he walked in to the premises.
Yeah, Your Honor, thank you. I mean, it's all glass, door probably being opened. Knowing myself, being an ops guy, I would have pushed the door, got in, like you would, Your Honor.
Yes. So I put it to you that as of the 10th of November 2019, you actually were on Ms. Kakari's premises physically. Agree or disagree?
I disagree. I mean, my premises, I'm the landlord, but you've got a construction site basically. So it's not like, if you've done a fit out, there's a nice door. You basically
Yes.
have, you push the door, you get in, if a door at all. I'm not even sure there was a door at that time. So you just walk
Mr.
in, it's a
Diba,
construction site.
I'll leave the rest of what I have to say in submissions because
Yes.
it is.
All right.
clear
Well, don't
that-
tell me now what
But-
you're going to say in submissions. Do you have any
Yes.
more questions?
Not on termination date, Your Honor, and now going to move on to my second and final topic for Mr. Diba.
Well, I'm sorry, Mr. Lee. You've now gone 10 minutes over your allotted time.
Your Honor, yes, I did go on the basis that it was an estimate of time. I was not helped by the fact that Mr. Diba.
But
does not
Mr. Lee, I'm going to let you take some more time. But with the
Yes.
greatest of respect, you've asked a lot of irrelevant questions, a lot of questions which don't go to the matters that we're now dealing with today. If I'm going to let you ask some more questions, they're going to have to. Did you say they're related to the question of whether or not the landlord made reasonable efforts to re-let the premises? Is that what your questions are about?
Indeed, Your Honor. And
Well, they're going to have to be very directly related to that, and I'm not going to give you more than another 15 minutes. So,
Your Honor, yes.
so you're going to have to ask no war stories. You're going to have to go to the heart of the questions you want to ask and ask them very directly.
Yes. Your Honor, to make the best use of the time that you have given me, maybe I could first check, and it may well be answered below. Is there any specific aspect of mitigation that you were curious about and want me to direct my questions on?
No, it's a matter for you. I have read Mr. DeBar
Yes.
and Ms. Sharp's witness statements and about the efforts that they
Yes.
made to re-let the premises. If you're going to submit to me that they didn't make
Yes.
reasonable efforts, well, you need to bring out
Yes.
some evidence to show that. And it's
Yes.
a matter for you what
Yes.
your case is on that.
Yes. Mr. Diba, am I right to say that the first prospective tenant that you found for Mr. Kakari's units was that hair though? Is that yes or no?
Sorry, again, the name?
That hair though. That hair, and though is spelled as THO.
I'm under the impression, I'm going through my notes.
Yes.
COVID pandemic. So then we engage actively. I remember, probably the first one I remember is Yang Yang.
I'm going to be generous to you, Mr. Diba, and say there was someone even earlier than Yin Yang. Yin Yang was second in time. That
Okay,
hair though.
maybe we were better than that.
Yes. Look
But
at
in my
B4,
witness statement, I
page
can't remember
131.
Yang Yang. Yeah.
Yes. Look at B4, page 131.
Which page in the statement?
Yes, page 131 of your of the bundle. That's your exhibit. B4, page 131.
Okay, so it's a document by IREP, right?
It's a document that is your tenant acquisition report, and it does say IREP on the top left hand corner.
Yeah. So it's a document
Yes.
prepared by a broker.
If you were to go down like four rows down, that hair though, and the units are RT 211 to 213. Yes, RT 211 to 213 are Ms. Kakari's units. Am I right?
Yeah, so that's August 2020, right?
Yes, that is August. No, sorry, that is July. It says, if you look at the annotation, it says viewing held on the 6th of July.
Yeah, that hair, I can see it.
Yes, that's right.
About the same time as
Yes.
that same IREP partners doing a viewing for Yang Yang, right? So about the
If you
same
say so,
time,
Mr. Diba,
Yeah, in my statement, 21 of July 2020, you can see there's a viewing for Yin Yang.
Yes, Mr. Diba, I will ask you questions about Yin Yang later on. If you were to look at that, do you confirm that that hair though was the first prospective tenant that you found for Ms. Kakari's units?
I wasn't dealing with that client, and it's not my report, so I don't know about that.
And it begs the question why you're being called as a witness by Emirates REIT today, if you have no knowledge of so many things. But coming to that, let me be kind to you and say that that's in your witness statement and Ms. Chloe Sharp's witness statements, there is no mention of any earlier prospective tenants.
If
there is, tell me where is the evidence of earlier prospective tenants than that?
If you remember, Mr. Lee, I mean, I'm going to maybe reverse the question, but
when was your case?
Yeah,
if you were to give a straight answer, because if the answers that you give are all not straight, it doesn't assist, well, it's not just me, it doesn't assist the court as well. So if you just confine your answers, is there anyone before that hair though that was a prospective tenant? Yes or no?
No.
No.
Well,
fantastic.
Not that I know of.
I expected no less from that.
Wait,
yes,
wait.
Not
that I know of, bearing in mind you had COVID at the same time, yeah?
If there is, Mr. Diba, I'm not going to leave this door open for you to argue that subsequently. If there is, surely, there would be evidence of it that you have adduced. Why did you not adduce it if there is someone earlier?
Sorry, can you reword
Why
that?
did you not produce evidence of any potential earlier tenants other than that hair though, if there were anyone earlier?
I don't think I'm aware of anyone, but I mean, I'm not in front of the records of the system, right? But I'm sure we looked, and the first offer we got was actually from that Yin Yang, which is as per my statement.
I'm very happy if that's the first offer because it's even later in time. But I'm being generous to you, Mr. Diba, because what I'm going to put to you, Mr. Diba, is with that hair though, the earlier one, even earlier than Yin Yang. It was, if you look at the tenant acquisition report, it says that viewing held on 6th of July. There is no evidence of anything being done earlier than 6th of July, right? Even if we were to take your previous employer's case at its highest and consider 10th of January as the termination date, you agree with me that there's no evidence of anything being done to market Ms. Kakari's units, or rather, would you agree with me that there is no prospective tenant that you managed to find before 10th of July 2020, before 6th of July 2020?
Mr. Lee, I don't think the court has 20 minutes for me to go and check the discussions with all the brokers we've had.
All I need is to ask you, do you have any evidence in your own witness statement showing the opposite of what I'm saying, that there was someone earlier? If there is anything, Mr. Diba, it should be in your witness statement now.
Mr. Lee, can you stop answering to my questions? There's plenty of evidence, starting with the emails to Kaizen, etc., where we're asking them to start looking for clients. Obviously, I wasn't the one doing the client visits, unless they get to an offer.
Let's talk about Kaizen then, Mr. Diba. For Kaizen, you said that you asked them to find a replacement tenant from November 2019. Where is the evidence, apart from your own say-so, where is the evidence, correspondence, etc., of you asking Kaizen to start looking for a potential tenant? I found none. Perhaps you could find some and tell me where it is.
I mean, I'm sure, I mean, if the court has, a couple of months to recess and we can go through the emails, but I'm pretty sure, look, everything I was doing was through emails. So,
yes. Your Honor, I would stand guided by you as to whether I should move on or press this further, because I do feel
well, it's a matter for you, Mr. Lee, but I suspect you've gone as far as you can with that.
Your Honor, yes. Now, you said that you had approached Kaizen. Who else? IRE Partners. You had approached CB Richard Ellis. Where is your correspondence with IRE Partners and CB Richard Ellis saying, please market for Ms. Kakari's units, please market for them all? Where in your
Yeah, I'm sure they have. Look, I wasn't the leasing manager, right? I was head of real estate.
I am asking, where in your witness statement, where in your evidence is there such evidence?
I'm not the witness for such evidence, so it's a leasing matter, but those people would have engagement letters and mandates signed. So they're active people in relationships with Emirates REIT.
Okay, I note for the record that you could point me to no single piece of evidence, even in your own witness statement, about correspondence of having approached Kaizen and having approached IRE partners and having approached CB Richard Ellis. Mr. Diba, do you have any idea?
This is not what I said, by the way. You've got reports of IRE, you have reports of CBRE. I mean, there's lots of evidence showing the broker's activity from November 2019, but I'm sure Mr. Boo would be happy to provide more if you want.
I'm talking about you approaching them specifically to let out Ms. Kakari's units. Do you have evidence of that?
Remember, I wasn't the leasing manager, right? So I can report you on what I was doing as head of real estate.
Question is not what capacity you are. I know you're the big boss, Mr. Diba. The question is, in your own witness statement, in your own evidence, do you have any evidence of any correspondence with H? Let me help you, Mr. Diba. With H&H, there was something official at least. There was a proposal that they gave you. There was. That's why I not asked about H&H. I give it to you. With H&H, there is.
Right? H&H is, yeah. Because the others are
but with the other three, is there similar documents showing that you approached them? Yes or no?
I think you're a bit confused. So just resetting on that. H&H first mandate was to write a strategy paper, which is why they have a contract to write a strategy paper, which is followed by leasing. Now, in market practice, when you work with brokers, you send them. So the way the market works, okay, so it doesn't work with engagement letters. So you send them a availability list. They have brokerage mandates. They know that when they lease, they're going to get that much money, and that's how it works. That's how the market works.
Mr. Diba, I'm going to give you a chance to give me a straight answer to my questions because I'm going to be submitting that I'm incapable of getting a straight answer from you. For every question that I ask, you go around the bush with a lot to say, but you don't answer my question. And I'm going to say that weakens your case. I'm going to give you a chance to correct your approach. Now, let's look at the H&H. Let's look at what you have in your dealings with H&H. Please refer to, and let me just, you want to please give me a bit of time because I'm jumping very far ahead in my list of questions just to observe my 15-minute deadline. I'm free, yes. Please look at your B1. Yes, no, I want the actual report. Yes. Let's look at the documents that H&H prepared, starting at B2, page 87.
Page what?
B2, page 87. 87. Yes. The H&H letterhead. Are you on that? Your Honor, are you on that page?
Yeah.
Yes. Now, it is dated 22nd November 2020, yes?
Mm-hmm.
Yes. So yeah, we're on the same document, and H&H calls it a letter of engagement. Now, if you go a few pages ahead to page 91, that is a start of a document also prepared by H&H called the commercial proposal. You see that?
What I'm opening.
Yes.
Yep.
Yes. So if you are on that now, please go to page, it's within the same report, page 97. So that is part of the commercial proposal. Are you at page 97?
Yep.
Now, please look at this within the elements list. There's a list with a header called elements. Item number 14, it says retail 211. Is that right?
Which page are you on, Mr. Lee?
Page 97, Your Honor.
Sorry, 87.
97. 97.
97. Okay.
Yes. Yes.
Yes.
Yes. Page 97. Do you see that, Mr. Diba? Item number 14, retail 211.
Mm-hmm.
Does that refer to Ms. Kakari's units? Let me help you. Yes.
Yeah.
14, 211.
Yeah.
Yes. Now, Ms. Kakari is 211 to 213, right? But even though this says 211, if you look at the area, the floor size, it says 247 square meters. Do you see that?
Mm-hmm.
Which is around 2,600 square feet, which is Ms. Kakari's 3 units. Yes?
Yeah.
Now, under VKBOT, what are your instructions to H&H? Currently leased. How do you expect H&H to go and market for Ms. Kakari's units when you, in your very own instructions, tell them that this unit is currently leased?
Look, in real fact of leasing of life, okay, they knew very well we had to find a replacement tenant for there. Now, I cannot remember if the lease was on my side terminated, right? In case it wasn't, then you do informal visits, because I believe we actually terminated, only from my operational perspective, I believe we only terminated the lease like the day before we signed the new lease with the chauffeur, right? So obviously they knew. I mean, they're brokers, right? So it is in their interest. And that salon is in the super prime location of the mall. It's bang as you walk in on the left. So obviously any broker would have interest to lease the unit.
Right. Mr. Diba, thank you for your long answer. That does not answer my question, but let me move on. Now, my next point I'm going to put to you is that you have not shown similar evidence of instructions to IRE partners, to CB Richard Ellis, and to Kaizen. Why is it not open for me to ask this court to assume that you gave similar instructions,
Well,
excluding Ms. Kakari's units to the other 3? Tell me, why is it not?
I'll tell you why, Mr. Lee, because you keep asking the same question without listening to my answers. The question is, the mandate that I gave to H&H, okay, was a mandate to do a strategy and then to do leasing. Therefore, there was a strategy and there was a lump sum payment. We're paying them to deliver the strategy. The other ones are brokers. So they have a brokerage mandate, which is purely success fee based. So they have umbrella mandates, and they will only get the money the day a lease is signed. So that's how it works. So it's 2 very different relationships, and our best efforts to lease the shops illustrated through our reach to the clients, the number of visits you can see, all the interaction with CBRE, with Kaizen, with the whole brokerage market.
Mr. Diba, would you please look at, turn a few pages back to page 88, which is also,
38 or 88?
Yes, 88. 88. It's for the same document that H&H sent. The very top paragraph says the leasing agency will not verify the data you submit for accuracy or completeness. Rather, we will rely on the accuracy and completeness of the documents and information you provide to us. So now there we have it. In your own instructions, you say it's currently leased. You say there were separate instructions given, which is not in evidence. Why can we not look at your actual instructions, look at H&H's disclaimer, and say that, look, you must have excluded Ms. Kakari's premises when you give instructions?
I mean, just bear in mind, it's the proposal, right? I would think when you've got a proposal, basically you look at the main scope, and you look at the main scope at how much you're going to pay. So you actually don't look, at the nitty-gritty of a broker's proposal, which was, this is already on page 37. You think I'm going to read 50 pages of all of my suppliers? On the back of that, there would have been a purchase order by Emirates REIT, which says, consultancy services, whatever amount it is. So look, this is not written by Emirates REIT. This is written by H&H, and I don't see how it's relevant to whether we were leasing or not leasing. For me, look, it was in my best interest to make sure the mall is leased and the shops are open, right?
Mr. Diba, I'm now going to move on. Again, I'm incapable of getting
Yes, Mr. Bull.
answer from.
Sorry, Your Honour, we have exceeded 2 hours now.
I know.
So-
I think we're about 2 hours. I was going to give Mr. Lee another 4. My calculations where he's got 4 minutes to the 2. Sorry,
right.
5 minutes to the 2 hours. That's when I was going to call him. But
Okay.
again, Mr. Lee, you really need to go to your very best questions now because you're running out of time.
Yes. Now, Mr. Diba, when you found the ultimate tenant, which is Shavu, I mean the one that actually, when I say ultimate tenant, I mean the one that actually took on the lease.
Yeah, sure, yeah.
Yes. What was the rental? Now I know it's redacted, so I am going to be very careful in the way I ask it. Would you agree with me that it is significantly lower at the initial stages, at least, and that's not redacted? Let me get you the page reference.
What I remember, yeah.
Yes.
Yes, Mr. Bull?
Yes,
I think it's
sir.
a matter of mathematics. The numbers are the numbers.
Yes. Well, I don't know what the question's going to be yet. We know it was rented out for less, Mr. Lee. We know that. What is your question?
Yes. But I think it would be better if I were to go to the document page just to make sure that everyone is on the same page. Literally. Now, if you were to go to page 869 of the bundle.
869.
869, yes. And that is section M. M for Mike.
Is it the lease to Cheveux? No, yeah. Okay.
Yes.
M.
Yes.
869 is the lease, right?
869. Yes, that's right. That's your lease with Chevaux, is that right? On the tenant, other tenant, it says Chevaux Limited.
I'm sorry, what was your question, Mr. Lee?
Yes. Look at the initial. Now, a lot of it is redacted, so I do not know the total rent. But just looking at the initial rent alone, it is in the region of 70,000 dirhams every installment. Is that right, Mr. Diba?
Look, I mean, it's mathematics, as Mr. Bull said, but we work in, my mind
Let's
works
help you.
in dirhams per square
The
feet.
first item says 67,424. Second is 67. Third is 67.
Yeah.
And after is 74. So it's in the 70,000 dirham region. Am I right?
I don't have my calculator, Mr. Lee, so don't take me on my math.
Okay. Mr. Diba.
I mean, right, yeah.
Yes.
What is your question, Mr. Lee?
Yes. Miss Kakari's units, the initial rent alone was in the 200,000 dirham region. So even without knowing your full figures, because they are redacted, why did you accept such a low rent from Chevaux? You have an explanation in your witness statement, but I'm not going to help you. I'm going to ask you.
I'll allow that question, Mr. Bull. Question is, why did you accept that rent?
Yes.
I mean, basically, the market situation had changed dramatically. Both the management and the market situation had changed dramatically from, the time at which the lease was entered for the salon, and to 21. Basically, just past COVID. Honestly, we were pretty desperate to lease the mall because the mall was pretty sad. Yeah, there wasn't much people. So basically, I had the mall was never seen by Emirates REIT to be a cash machine. But
Yes.
the mall was always the place that needs to be vibrant to bring life to the whole tower, which is where the value is. So clearly the mission was, okay, lease. And
Yes.
honestly, that's where the market was at that time. The market was pretty much at 150, 160 dirhams per square feet. And I believe we entered into a lease starting at 145 for the first year, 160, 165, 165, 170. That's pretty much where the market was. Today, you've got a market, that starts at 220 to 40. So yeah. Now,
Mr. Diba, yes.
Yeah.
Look at paragraph 53 of your witness statement. Let me help you a bit there. 53 of a witness statement, and that is at page 50 of the trial bundle. B1, page 50.
50, yeah. Yep.
Are you there? 50. Look at paragraph 53.
Yeah.
Subparagraph C in particular. You say the new tenant, and this is Chavot, was of exceptional profile and clearly had the funds, knowledge, and relationships to carry out its commitments under the lease. So why do we not see evidence of you negotiating harder, or you or your employees, I know you're the boss, as you just pointed out, of you negotiating harder with a party that clearly was exceptional and clearly had the funds?
I'm sorry,
mean-
what is your question, Mr. Lee?
Why is there no evidence of even any negotiation of the rental with Chavot? So that relates to the issue, Your Honor, that it relates to is the reasonableness of quantum.
So you want to ask Mr. Debar about the negotiations with Chavot?
Yes.
Well, ask him about that.
Yes. So on rent, why is there no evidence of any negotiation on the rent?
No,
with
don't
Chavot?
ask him about what the evidence is. Ask him a question.
Understand, Your Honor. In fact, I'm grateful for that. Mr. Diba, what was your negotiation on rental with Chavot?
So I wasn't the one negotiating directly, right? At the time,
I see.
it was, a member in the leasing team. Now the market, it was leased at pretty much where the market was. And clearly those people came in the middle of COVID. Retail market had been through a typhoon. And, the people that were willing to take positions at that time made a good deal. So they made a great deal. But honestly, today they're at Cheveux. Today they'd be paying 180 or 190. Today the market's at 220, right? So what, they're probably 15% below where the market is. Now there was a huge correction in the market between 218 to 217 to 18 to 224.
So, but to be fair to you, we could well be in a situation where it's a he says, she says, you say it's fair, I say it's not. Now, the best indication of whether something is fair or not is market data of actual last transacted prices for similar units in similar properties. Why did you not make reference to that to show that you had, because you know very well that you have to show that the quantum you are ultimately renting out to is reasonable. Why did you not put up any market data of last transacted prices?
I mean, we're not merchants, right? We're not real estate brokers. So obviously, look, the value of the leases, it's what drives the value of the property. So we are clearly incentivized to rent as high as possible. Now you need to be in your market, so we were in our market.
Yes, carry on, Mr. Diba. I'm listening.
Sorry,
do you have anything to add, Mr. Diba?
No, ask him a question.
Okay, thanks. I just wanted to make sure that there was nothing else he was going to add. Mr. Diba, let me just go to just one of the previous tenants. Please look at Yin Yang, right? B2 page 66. And I'm going to ask you to put a bookmark at page 66, and then to also go at page 133, also on B2, page 66, and page 133. Now, Mr. Diba, are you at page 66? Please look at the email, the second email at the bottom of that page from Siobhan Coy, right?
Yeah.
And it starts with saying, "Dear Sabine and Victoria, my client, owner of Yin Yang Salon, etc., wishes to move to the offer stage for units 211 to 213. You read the rest yourself. I am going to ask you to pay particular attention to their request for rental at the last paragraph, which is starting at AED 180 and finishing at AED 200 per square foot in year 5.
Yeah.
Yes. Please look at page, the other page that I mentioned was page 133. Please go there now.
133?
Yes, 133. Sorry, just put a marker there. Mr. Diba, do you remember, put a marker at 133, but you don't have to look at it. Do you remember, Mr. Diba, what was the ultimate rent that you offered for Yin Yang?
Was it 180 per square feet?
Put there. Yes, look at paragraph 34 of your witness statement, which is at B1, page 47.
Sorry, what page?
Your Honor, it is page 47, 47.
Okay.
Yes. So, Mr. Diba, are you on paragraph 34? Please look at paragraph 34.
Yeah.
Are you there, Mr. Diba? Yes. You
Yeah.
see that for Yin Yang, your initial rent, yes, you did honor the request for 180 dirhams per square foot. Then year 5, they asked for 200. You counter proposed with 210 dirhams. It is very clear that when you want to, Mr. Diba, you can be a very, very shrewd negotiator, even down to the last dirham. Why do we not see express indication of you negotiating with Shavu over the final rent?
I mean, there would have been discussions. Trust me, there would have been discussions.
Yes. And now page 133, the discussions. Look at page 133. I know you were in discussions because your tenant acquisition report of 1st September 2020 at page 133 does say with Yin Yang second row. Mr. Diba, when you're there, let me know.
Yeah.
Yes.
So we're on page 133.
133. Your Honor, second row, it says Yin Yang / Salon Premium. And that's Ms. Kari's units, 211 to 213. Right. It says client to respond with a counter offer. Right. So there were discussions. I know there were discussions. Why did you not follow up? Why did you not follow up on the to chase for the counter offer?
I'm sure there was some follow-up, but by the way, the ones following up are the brokers, so IREP, right? Remember, I was the head of real estate, so I was heading the division. Now I believe, although I can't, they decided not to proceed. Yang. So
yes, Mr. Diba, we can only go on with what is the evidence in front of us, not what you say there is. If we can do that, I can equally say that Ms. Kakari cannot produce it, right? It's not in evidence, but she has a signed forgiveness from Emirates REIT for the full 4 million dirhams. And if I were to say that you must accept it, even though it's not in the evidence, Mr. Diba, surely.
Sorry, can you just stick to your questions, Mr. Lee? You can make submissions to me later.
Yes. Mr. Diba, I am I think I've got enough to make my submissions on the mitigation or lack of mitigation by Emirates REIT. So I do not propose to go on any further. And before I hand over to Mr. Bull for the re-examination, Your Honor, is there anything that you wish to ask of Mr. Diba before I?
It's your cross-examination, Mr. Lee. I'm not.
No, I'm perfectly
asking
happy now then
questions.
to hand over to Mr. Bull.
All right. Thank you. Mr. Bull.
I have no questions, Your Honour.
All right.
Satisfied with the evidence in chief.
All right. Well, Mr. DeBar, thank you for your assistance. That completes your evidence. You are now free to go about your business. Thank you for your help.
Thank you, Your Honour. Thank
Thank you, Mr. Diba.
Thank you.
Yes.
All right. Now, we were scheduled to take a 10-minute break, but we've gone well over those times. I think the timetable said we would take a lunch break at 13:10, which is about another 20 minutes away by my calculations. Perhaps what we'll do is we'll start Ms. Sharp's evidence and then we'll take a lunch break at approximately 13:10, somewhere around that time.
Thank you, Your
So
Honour.
do you have,
I would like
Ms.
to try and
Sharp?
proceed with Ms. Sharp because she has been waiting.
Good.
And yeah, that would be good. I will just need 5 minutes though to set her up onto the computer. And
All right.
and, yeah, happy to resume very shortly.
All right. Well, we will take a 5-minute break, and we'll resume at I think it's 12:51. We'll resume at 12:56.
Okay. All right. Good. I'll do my best to get her on in time.
All right.
Thank you.
Thank you.
Thank you.
Well, Mr. Bull, I can see you're back. And Mr. Lee, is Ms. Sharp now available?
Yes.
Yes, I can see her there. I'll ask the court officer. Oh, Ms. Sharp, do you wish to take an affirmation, or if you want to take an oath, you'll need to have a Bible with you?
Affirmation, please.
All right, I'll ask the court officer to administer the affirmation.
Thank you. Please confirm your full name and occupation for the court's record.
Chloe Sharp, Commercial Leasing Manager at Emirates REIT.
Thank you. Please repeat after me. I affirm that I will say nothing but the truth.
I affirm that I will say nothing but the truth.
Thank you. Thank you, Your Honour.
Thank you. All right, Mr. Bull.
Thank you, Your Honour. Ms. Sharp, thank you again for your attendance today. I will just display on the screen in a moment a copy of your witness statement. And 1 second. So, Ms. Sharp, do you agree that the document on the page here in front of you is the witness statement that you made? It's on pages 120 to 124 of the bundle, and that this is your signature here on this page?
Yes.
Is there anything in relation to this document that you, having reviewed it in preparation for today, that you think needs to be adjusted or altered or amended or clarified?
No.
Good. And you believe everything in this document is true and correct?
I do.
Okay. Thank you, Your Honour.
Yes, thank you, Mr. Bull. Mr. Lee.
Obliged, Your Honor. Good afternoon to you, Ms. Sharp over in Dubai.
Right, thank you.
Yes, thank you. Now, Ms. Sharp, could I just I just ask you to go to paragraph 16 of your witness statement, and in the bundle, it is marked as section B3, page 122.
Sorry, what page?
122.
Thank you.
Yes.
Yep.
Yes. You mentioned that you deleted many emails. Is that right?
Yes, I don't keep all of my emails, correct.
Yes. You joined Emirates REIT in August 2020. Is that right?
Yes.
Yes. Back in 2020 and from then until now, were you ever given instructions by either Equitativa or Emirates REIT that Ms. Kakari's unit was part of civil proceedings and that Emirates REIT had a duty to mitigate its losses such that all evidence relating to what Equitativa did to find a replacement tenant must not be destroyed? Were you ever given such instructions?
I
Yes,
don't.
Mr. Bull. Just a minute, please.
These proceedings were commenced last year, Your Honour. I don't know why any such instructions would ever be given.
May I address that, Your Honour?
What is it? Yes.
Yes. While it is true that the DIFC court proceedings were commenced only in the third quarter of 2023, there were civil Dubai proceedings that were engaged in over the same subject matter, which is unpaid rent. And that was before Ms.
I haven't seen any evidence of civil proceedings. I've seen evidence of there being proceedings over the bounced checks.
Yes. So that's over the
Is
bounced
that what
checks
you're
in Mr.
referring
Kakari.
to?
Precisely. It's in Mr. Kakari's last witness statement. So Emirates REIT commenced civil proceedings wrongly in the municipal Dubai courts when they should have commenced it in the DIFC courts.
So, Mr. Lee, you say that Emirates REIT commenced civil proceedings in the Dubai onshore courts sometime last year. Is that what you said?
Let me give you the exact. Let me just go to Ms. Kakari's last witness statement.
Well, in a minute, Mr. Bull, we'll see what Mr. Lee has to say first.
Yes, getting the execution proceedings. Yes, this was for some post-dated checks that bounced. Yeah. Right, so it's over the rent. Wait, where is that interval? Where is the interval? E5? 8? E6. Yes, page. Yes. 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 Your Honor, if I could refer you first to Mr. Kakari's witness statement, which is at B5. Hey.
So what page?
B5, page 176.
176.
Yes. And if you were to read paragraph 18 and paragraph 19, that sets the context. Yes. And then for the exhibits, it is one tab down at tab B6, page 213 until 229.
If I can just provide one important piece of context here.
Yes.
The defendant in that case is not the defendant in this case.
Well, I'm going to try and see what the defendant. You're taking me to 213, Mr. Lee.
Yes. Mr. Wu, who do you say the defendant in that case is?
Wait a minute. Let's before we get there. So,
yes.
This is a case. I see there are checks written by VKA Ladies Beauty Lounge LLC.
Yes.
So, right. You're telling me this was an action against that company for bounced checks?
Your Honor, this company never got formed. That's why Ms. Kakari is being sued in her personal capacity right now. For all intents and purposes, VKA...
Can we cut? I might be able to avoid all that. Was this an action for bounced checks?
Yes, it was for an action for bounced checks over the same lease.
So it was not an action for outstanding rent in which any question of mitigation was involved.
It
Was an
these
action on the
were-
checks.
These checks were the rent that Ms.
Yes,
Kakari
but
was
the
paying
action
on the
was
same disputed
for
lease.
dishonoured checks.
Yes, it was for dishonored. It was for dishonored checks.
That
Yes.
there was no question whether or not the lease had been terminated, whether or not the landlord had made any reasonable efforts to mitigate, were not an issue in those proceedings.
I see where Your Honour is coming from, and that yes, I stand guided, Your Honour. Yes. Ms. Sharp, were you ever in or shortly before October 2023, when these DIFC court proceedings started, ever instructed that because there is these civil proceedings going on, you are not to destroy any evidence relating to the finding
Sorry,
of a replacement
when was your
tenant?
question from when?
October 2023, Your Honour, when this action was started.
Right, so you're asking
Yes.
her from October 2023, was she ever instructed not to destroy any documents relevant to this case? Is that your question?
That's right.
Well, I'll let her answer that question.
No, is the answer.
You were never. Okay. Okay.
After October 23.
Yes. Yes. So you were not given any specific guidance about the risks relating to evidence destruction.
No.
Understand? Back in 2020, when you came onto the scene, when you joined Equitativa, what were Mr. Diba's instructions to you about finding a replacement tenant for Mr. Kakari's units?
I mean, I think probably there wasn't any specific instructions for that specific unit. My role is, commercial leasing of the full portfolio. Index Tower is one of our flagships, or is our flagship building. It's the biggest within our portfolio, and there's real focus on that building, specifically the tower and Index Mall as well. So
Yes.
It wasn't necessarily to focus and drill down on one specific unit. It was about, pushing all leasing.
The last part,
Yeah.
Ms. Sharp, the last part, after you said there was no mention of focusing on one particular unit, then you were cut off. I couldn't hear the rest.
So yeah, I was
Yes.
just basically saying that there wasn't a focus on one specific unit. It's,
Yes.
my role is leasing for the entire portfolio. Index is our flagship building, one that, is a fantastic building in its positioning and its offering.
Yes.
So of course we would look to, be leasing all units. We wanted just to continue to lease, basically.
I see. Okay. In your witness statement, you did say that Ms. Kakari's units were in a not so good part of the mall, so they were hard to lease. Is that right?
So yeah, I mean, I think basically though the three units are
Yes.
they're kind of as you come through the connection of the Gate Avenue coming into Index Mall, and it is a very good prominent unit. However, it is sort of like tucked a little bit to the side, and that's what
Yes.
I mean by that. Yeah.
I see. Okay. And this connection was built and completed only in June or July 2020. Is that right? The gate connection.
I believe so, yes. I joined in August 2020, and I believe the connection was open then, yes.
Yes. At paragraph 18 of the witness statement, it seems to me that there were approximately 100 prospective tenants interested in various units in the mall. And at the end, only that Heather, In Yang, Hair Creators, and Chauveau actually expressed any interest and took any further concrete steps towards viewing the unit. Is that right?
I think, look, there was, of course, there's a substantial amount of clients or prospective tenants that are coming, into the mall, and of course we're showing each of the units. So yeah, I mean, we were just obviously pushing everything that we could to show the unit, showcase the building. It was a challenging time because of what happened. As we all know, with COVID, Index Tower as well at the time was, under sort of large construction with the connection to the DIFC, and Index Tower as a whole was kind of a building in isolation with regards to the rest of the DIFC. It was challenging, but of course, people would always as well generally be kind of polite as well on viewings, and then perhaps you'd follow up with the agency and then find out that they've chosen another location with more footfall.
Right. Did you suggest to any of the other tenants who did not express an interest in Ms. Kakari's units that Ms. Kakari's units, well, it's 3 units, they could be leased out as single units, they could be leased out in a 1-2 permutation? Did you ever suggest that to them?
I think probably if we had a tenant that was specifically, keen on that unit, and they said, actually, we only want to have, half of it or whatever the case may be, definitely we would have had discussions as we do with all of our leasing. I don't recall at the time anybody saying, I want these 3 shops, but actually I only want one of them. It kind of flowed when you walked into the unit as one unit.
Yes. Understand. So you will wait for a tenant to express an interest before offering that. That means you did not proactively offer that.
I mean, if it came up during the viewing, then yes, but we wouldn't, actively specify that these units can be individually leased. We'd have also other units within the mall which were potentially of a smaller size. So, maybe you would show them that as well. But we would do everything in our power to lease any unit.
Okay. Would you agree with me, though, that if you had offered that as an option, that might have increased? That means instead of waiting to talk, right? You actually offered that.
Yeah,
would you
I think if we didn't have smaller units within the mall, available, then this would be perhaps a different conversation. But I think, from the clients, let's say, that were being approached and were coming to the viewings, we were kind of doing what we could, and we didn't even lease a smaller unit, for example. During that, it was just a difficult time.
Yes, I understand. Those 3 units, if they could have been rented out on an individual, I know that, well, as events happen, you did not. But if you could, were they of roughly equal size, these 3 units?
Sorry?
Were the 3 units of roughly equal size?
Yes. I would need to verify. I can't remember the individual size of the unit. Sorry.
Certainly, yes. If you had managed to find to lease out 1 or 2 of these units, you would have been able to collect rent on those units, which would have offset the losses that you had incurred. Do you agree with me on this point?
I mean, I think any unit that you begin to lease, of course, with it being a retail shop, and of course with it being shell and core, you have to offer a kind of grace period anyway, so you don't immediately get any returns.
Yes. Did you, out of the 100+ prospective tenants, did you try to divert their attention to Ms. Kakari's units?
Of course, I mean, it was all units ultimately, but of course, we would do everything that we could to lease the units, get them all kind of becoming a buzzing, vibrant community that actually it is today.
Yes. Now, coming back to paragraph 17 of your witness statement, and again, that's at page 122 of section B3. Right. You said that you give in your evidence here a sample of the various emails that you sent to the prospective tenants. May I ask, how big is this sample size of all the emails that you sent?
Sorry, what's the question? Sorry.
So paragraph 17,
Yeah.
you say that attached at pages 20 to 46 of CSI is a sample of the various emails that I sent to prospective tenants.
Okay.
Yes. And then you have, of course, those emails at page 20 to 46.
Mhm.
So this page 20 to 46 is a sample of the entire universe of emails that you sent out.
Yes.
I see. Okay.
You know,
What's your estimate as to the entire universe of emails that you sent out, of which this is a sample?
I look, honestly, I don't know the number. You know, we were approaching people by email, we were phoning companies. You know, if you were even walking through another mall in another area, like we obviously had several different other assets as well across Dubai, and you know, we was even engaging with those to try to bring them across to Index, actually, to see if, you know, they wanted to expand.
Okay.
And as well as, of course, with engaging with the agents and making sure that when they had an inquiry for DIFC, that they were bringing them to Index.
Right. Okay. Why did you not include the rest of the emails, given that this whole proceedings now is on the efforts that Emirates REIT did or did not make in finding replacement tenants? Is there any reason why? Yes.
I mean, obviously, look, we found what we kind of found, and you know, what I was trying to do is actually target a lot of different companies. So I would be Googling, for example, different companies, and then sending emails directly to them. So for me to kind of recall every tenant that I was, you know, approaching back at that time, was a little bit challenging. So I found the ones that I could find and provided
Understand.
those.
Understand. As I was reading it, I saw that those emails did not pertain specifically to Ms. Kakari's units. Is there anything that I missed out? Was there anything that pertained to Ms. Kakari's units?
No, because I would never operate in that way. You know, it's about bringing the client to the building, showcasing what's there, you know, strategizing with the clients or prospective tenants, and then showing them, you know, each of the units. You know, a tenant will have their own idea of where they want to be placed in the mall. So it's very difficult to me to reach out to them and say, you must look at this one specific unit. We're looking at the mall as a whole.
Yes. And you mentioned in the same paragraph that there was a brochure that was produced. May I know who produced the brochure?
So we produced it in-house. We have like a marketing team, but with the assistance of H&H for the strategy of the mall.
Right.
So it's a company called Tomato, yeah.
Yes. How much would you estimate the cost of producing this brochure to be?
I wouldn't know.
Yes.
To be honest.
And do you have evidence of payments for this brochure, invoice, receipts, etc.?
No, I mean, my role is merely kind of leasing, so I wouldn't really get involved in any of the invoice payments, specifically to suppliers or external parties.
Right. So if there is no specific number, even for this brochure, what makes you so confident to say at the end of that paragraph 17 that the claimant was sparing no expense?
I think in terms of, it's not, you know, look, I don't have to necessarily know the amount in terms of a figure. I think it's just about, you know, us obviously doing everything we could. We paid for the strategy through H&H. Again, I'm not sure of the cost of that. You know, this brochure, doing a kind of retail tenant mixed floor plan, engaging with different agencies. And I think, you know, that's kind of what I mean by that line.
Yes. Now I'm going to ask you something about Mr. DeBar's exhibits and witness statements about H&H. If you don't have personal knowledge of it, just feel free to say that.
Okay.
Because you mentioned H&H and there was a strategy document. In Mr. DeBar's evidence, we only see that there was an initial approach, an engagement, and an engagement letter and a proposal, but we see no follow-up after that. There was no evidence of payment or of the price that was paid to H&H for the strategy document. We see no follow-up. Are you able to assist us by pointing us to anywhere within your witness statement or Mr. DeBar's witness statement which shows follow-up with H&H?
For the payment, sorry, or follow-up for what?
Right, okay. Let's break this into, because I realize I'm asking two questions at one go. Payments, just for payment to H&H. Is there any evidence of payment to H&H?
I mean, I don't know, to be honest.
Because that's not within your job scope?
Unfortunately, I don't get involved in the payments, to be honest. So
oh, I see. I see. Okay, I understand now. Now, were you involved in the negotiation with Chauveau, which was the ultimate replacement tenant that came on the scene?
Yes, I was involved as well during the time. Yeah.
Yes. Okay. So the exhibit of the rental schedule that was given to us is redacted. So unfortunately, we don't have the full. I'm sorry. I should give you the page reference first. That is page 869 on section M.
Okay.
Yes. Are you familiar with the terms of the lease of Miss Kakari?
Not for VK Beauty, no, or Miss Kari, no. This was before my time.
Right, understand. If I could assist you by turning to Ms. Kakari's actual rent schedule. Let's page 387 on tab B8, Bravo 8. Page 387. Do you have that page, Ms. Sharp?
It's just buffering. Here we go. Yes, now I do.
Yes, okay, yeah. So if you put these two schedules side by side, just for the initial installments, you'll see that Ms. Kakari's initial installments are in the region of 200,000 dirhams. Whereas for Chauveau, it is 70,000 dirhams after you average opt-ins. So there's almost 2/3 haircut, right? When you were involved in the negotiation process, tell us what steps did you take to try to get the best possible price? Because it looks to me, just based on this alone, it's a very, very big haircut.
So I think my understanding is that there was, this amount of money that was passed across for the fit out, and within their base rent, actually, this was being.
Sorry, just a minute, please, Ms. Sharp. Mr. Bull, you wanted to object?
I just want to ensure that we are comparing apples with apples here, and the periods.
We'll see. We'll see.
I just
I don't know where this is going.
No, but
the question that I've understood was, what efforts did she make to get the best price out of Chauveau? And so far, the question was doesn't ask anything about the comparisons between the two rents.
Okay, just when we are comparing those schedules, though,
Yeah, she was
periods.
taken
One
to them,
refers
but
to 3 months.
the question doesn't ask her to compare them. The question was, as I recall it, the question is, what did Ms. Sharp, what efforts did you take to get the best rent you could?
Good. Thank you, Your Honour.
Yeah, thank you. I think at the time, you know, we were having a lot of meetings. I recall, you know, having meetings with the client, and of course, you know, our job is to get the best and highest rental price that we can. The market was, of course, a factor. I believe that we were in line with the market, and I think at the time we were all, you know, relatively happy with the deal that had gone in place, specifically as well, knowing that that was going to try and, or was going to sort of reignite again the mall.
Ms. Sharp, did you think of trying to get last transacted price data to show what was the last transacted prices, not for purposes of putting in a witness statement, but for purposes of knowing what is a yardstick, reasonable yardstick that you could push for rent?
So so we would do market analyses just in general, as we do on a continual basis, to make sure that, you know, all of our assets are in line with the market. So definitely, you know, these kind of behind the scenes processes would have been in place. And you know, I don't recall if I specifically looked at, you know, a number of leases or you know, or any rental at that time. But yeah, I believe that we lease within the market.
Right. Okay. So your analysis would show market rate at that point in time that you for similar units in similar malls.
Correct. Yeah.
See, why is this not mentioned? Is there a reason why you did not mention something as important as market? What is the reasonable market price at that point in time in your witness statement?
No specific reason, to be honest.
Right. Okay. I hear you there. You have come across as a very credible witness, and the thing is, I'm going to put a question to you.
Yeah.
I'm going to ask you to agree or disagree, and if you agree or disagree, feel free to say why you agree or disagree. I have to put it to you because there is no evidence of this prevailing market prices or of your analysis or of the documentation of what you actually said to
Mr. Lee,
price.
Ms. Sharp doesn't know what all the evidence is before the court, nor is that her concern. She's here to answer questions that she's able to answer. Ask her a question about what she knows and so on.
Yeah. Yes. Ms. Sharp, I have to put it to you that I think, you know, that Emirates REIT and Equitativa did not make an effort to get the replacement tenant at the best possible rent. Do you agree or disagree?
No, I disagree. You know, we would always do everything within our power to get the best possible rates, that, you know, the best kind of clients in the building, the ones that would also benefit the community. So I disagree.
Okay, I move on.
Well,
yes,
we should take a luncheon break for those there. We're a little bit late, but can we also, given that things are running slower than had been anticipated,
Mr.
Can we make it half an hour and resume? So it is 13:30 now. Can we resume at 1400, 2 p.m. Dubai time?
Certainly, Joanna.
All right.
Yes.
Well, we'll now adjourn for 30 minutes and resume at 2 p.m. Dubai time.
Thank you.
Thank you. Mr. Lee.
For Your Honor. Sharp, I'm happy to let you know that I just have a few final questions for you about the 4 tenants. I do appreciate that you joined Equitativa only in August 2020. Your level of involvement is, not it's not been that long. Now, can I trouble you to go to page 131 of the trial bundle, which is your exhibits, and that's at V4. V4, page 131. And I'm covering the very first prospective tenant that was approached, and that's that hair though. Please let me know when you are at page 131.
Yes, I'm there.
Yes. So you see that hair though mentioned in the fourth row.
Yeah.
Yes. And it says viewing held on the 6th of July, awaiting confirmation from the client's investor before proceeding.
Okay.
Yes. Now, I think we'll wait for the judge to come on because His Honor has. Your Honor, may I check whether you're still there because your screen is you're off your
I
screen
see.
now.
Yes.
Yes.
Now, I'm not sure
Yes.
how that happened, but all good.
Yes. Yes. Ms. Sharp, no. In fairness, July 2020 was 1 month before you joined. So if for any question you do not have any personal knowledge, please let me know.
Okay.
Yes. Are you aware of any efforts that Emirates REIT tried to find a replacement tenant for Ms. Kakari's units before the 6th of July 2020?
I'm sorry, what was your question again, Mr. Lee?
Are you aware of any efforts made by Equitativa or Emirates REIT to find a replacement tenant for Ms. Kakari's units before 6th of July 2020?
Right, so your question is generally about efforts to obtain a tenant. It's not about whether anybody did an inspection.
That's right.
All right.
Yes.
Yeah, on this specific one, this is probably over a month and a half before I joined the company, so I'm not entirely sure, to be honest, what happened with that one.
Yes. Okay. And for Yin Yang, which was the second potential tenant, they came on the scene around July 2020. Do you also have knowledge? Did you work with at all on the Yin Yang lease? I mean, it didn't convert into a lease ultimately, but did you work on that file?
Not in terms of viewings, no. I may have been involved in that lease transaction in terms of entering it onto the system, for example, but honestly, I don't really recall back then, to be honest. I don't have them a strong presence in the front of my mind, let's say.
Understand. Okay, fair enough, because of the date that you joined. And
yeah.
Yes. The third potential replacement that Equitativa found by Emirates REIT was hair creators in March 2021. Is that right?
Mm-hmm. Yes, that's correct.
Yes. Now, between hair creators in March 2021 and the previous one, which was Yin Yang in July, that's around some 4 plus 3, 7 months plus, where there was inactivity. Is that correct?
I mean, I wouldn't call it inactivity. I think, yes, in terms of an official lease offer being issued, there's clearly inactivity. However, in terms of, us trying to fulfill leasing the available units, I wouldn't call it inactivity. As I kind of expressed, we have been engaging lots with agents directly with specific kind of clients that we would want to be in the mall. So yeah, but it's just unfortunate that we didn't get an official offer across the line during that period, but I think I've touched on briefly just
Yes.
before we took a break. It was a challenging asset, and it was difficult even when you undertook viewings there because of the low footfall, and the construction and plenty of competition.
Understand. Yes. Ms. Sharp, so that was I was asking you about the time, the lapse of time between the second and the third tenant. Now the third and the fourth one. So the fourth one, which is the ultimate replacement tenant, the lease was finalized on the 28th November 2021. Is that right? And to refresh your memory, you like to go to B1, paragraph 50, and that's Alan DeBar's witness statement. Is it right to say that the replacement lease was finalized on 28 November 2021, as Mr. DeBar says? So B1.
Yes, Mr. Glenn. Mr. Bull.
Just which page are we talking about in the bundle?
Oh, yes, Mr. Thank you very much for saying that. It's paragraph 50. So that would be just a moment. Let me just get you the page myself. Paragraph 50. That's page 49.
And then secondly, I'm not really sure it's appropriate to be using Mr. DeBar's witness statement as a reminder or prompt to the client, to the witness. I would suggest that if you point to a document in the exhibits.
So this is Mr. DeBar's witness statement,
Correct.
is it? And what
Yes.
paragraph are you directing her attention to?
Paragraph 50, Your Honor.
50. Following further negotiations on 28 November, I signed the lease leasing the premises to Chauveau. And what is your question that you want to put to
Yes,
Ms. Sharp?
to confirm that as far as Ms. Sharp is concerned, she concurs that 28 November 2021 is the date that the lease with Chauveau was entered into.
Do you know, Ms. Sharp?
It sounds about that date.
Yes.
I don't have the specific date in front of me.
Certainly.
Yes,
Ms. Sharp, you may
roughly
like to
December, I
refer
think.
to page 873 of tab M.
Is this a matter an issue, Mr. Lee? Why are we spending time on this?
Yes, reasonableness of efforts, the gap time between, I want to know what specifically was done in this gap time.
From
No,
hair
I do
creation.
appreciate that the documents already say what they say and do not say what they do not say. I just want to make sure that if Ms. Sharp has anything further to add, it's not this now on. So that's around 8 months as well. Was there any specific and you confirm that during these 8 months there were no specific marketing efforts for Ms. Kakari's units? That's correct. Is that correct?
I think, sorry to sound repetitive,
Yes.
but I think for us during that time, it was never actually taking our foot off the gas. It was continual engagement of them all, of our availability, assistance in viewings, and just in general trying to push our leasing. I think as well the discussions with Chauveau took place over a considerable amount of time, where multiple viewings were taking place, and then of course then you've got the negotiation period. So albeit it seems long, probably we were discussing with them a good 3 months, I would imagine, or can vaguely recall. I know it was a considerable amount of time, and yeah, just in general doing what we could.
Yes. Okay, I have your answer on that, Ms. Sharp. And I'm very happy to let you know that that's all I have for you.
Thank you.
So, Your Honor, yes.
All right, thank you. Thank you, Mr. Lee. Mr. Bull, do you have any re-examination?
I have no further questions, Your Honour. Thank you.
All right, well, Ms. Sharp, that completes your evidence. Thank you for your assistance. You're now free to go about your business.
Thank you. Bye.
All right. So now that completes the evidence you're calling, Mr. Bull.
Correct, Your Honour.
All right, and Mr. Lee, you wish to call evidence from Ms. Kakari, is that right?
Indeed, Your Honor, yes.
All right,
yes.
I see Ms. Kakari is on the screen, but Ms. Kakari, can you put your camera on, please?
Yes,
Thank you.
hello, good afternoon.
Hello, thank you. I'll ask
Good
the
afternoon.
court. Ms. Kakari, are you taking an affirmation or do you wish to take an oath? If so, do you have a holy book with you?
Yes, I do have, and I am able to take an oath.
Okay. All right. And I'll now ask the court officer to administer the oath. Thank you.
Thank you. Can you please confirm your full name and occupation for the court's record?
Yes, my name is Vasiliki Kakari, and I am a full-time mother, and sometimes I'm assisting my husband at his business.
Thank you. Please raise the holy book so that it is visible to the judge. Please repeat after me. Place your hand on the holy book. Yes, perfect.
This hand?
You can hold it and raise your hand. Perfect.
Okay.
Please repeat after me.
Sure.
I swear by the Almighty God
I swear by Almighty God
that I will say nothing but the truth.
that I will say nothing but the truth.
Thank you. Thank you, Your Honor.
All right, thank you. All right, now, Mr. Lee, you
Yes.
wish to have Ms. Kakari verify her witness statement or statements.
Yes, as it pleases the court, I will proceed with that now. Ms. Kakari, there is a trial bundle in front of you, but for current purposes, just to make things easy, I'm going to flash your witness statements on the screen so that everyone can see it. In the trial bundle, yes, there are 4 witness statements of yours in the trial bundle. Your first witness statement, your third witness statement, your 5th witness statement, and your 6th witness statement. I'm going to ask Ms. Monique Wan now to get those documents and flash them one by one on the screen for you for certain confirmations. Please bear with us for a while we get the documents.
Yeah, sure.
Yes. Computer is a bit slow, so please put up with us. Especially when we are opening the trial bundle. Yes. When I'm waiting, sorry, you've got this one Stacey as well.
Which one do you want?
Okay, her first witness statement, B11. Go to B11. B11 is over there.
It's just not showing.
Yes. Do you see your first witness statement on the screen, Ms. Kakari?
Yes, please, I can see that.
Yes. You confirm that your name and your address are correct?
Yes, I do.
Yes. I'm now going to scroll to the final signing page. Yes. Do you see that on the screen? Is that your signature?
Yes, please. I confirm. Yes.
And between the first and the last page, the contents of your witness statement, do you confirm that they are correct?
Yes, I believe they are correct.
Thank you. I am now going to move to the next witness statement, which is your third witness statement at tab B13. Do you see it on the screen, Ms. Kakari?
Yes, please.
Yes. And do you make the same confirmation about your name and your address on the first page?
Sure, yes, I confirm.
Yes. Next to the last signing page. Yes. On page 607 of the bundle, is that your signature on the
Yes,
last signing?
correct. That's my signature.
And do you likewise confirm that the contents from the first to the last page are correct?
Yes, please.
Now we go on to your fifth witness statement, which is at tab L of the trial bundle. Yes. And you'll see that it has a cover page and the next page, 817. You likewise make the same confirmation about your name and the address.
Yes, I do. I do confirm.
We'll now go to the signing page. Yes.
It's my
page eight.
signature.
Thank you. And you likewise confirm that the contents from the first page to the last page is correct?
Yes, I believe they are
Yes.
correct.
Yes, thank you. Now let's go to your final one, which is your sixth witness statement at tab B14. Yes. Okay. Again, the same confirmation about your name and address.
Again, I confirm.
Yes. To the last page. Do you confirm that it's your signature?
That's it. Yes, correct.
Yes. And you confirm likewise that the contents between the first page and the last signing page is correct?
Yes. Yes.
Yes. Yes, thank you. Unless Your Honor has any further instructions, I have no questions in direct examination for Mr. Kakari. Yes.
You allow
Sorry,
me,
Mr.
please?
Kakari. Yes.
Excuse me, Your Honor. I think I have 7 witness statements. This is not the latest one, I think. No.
In the trial bundle, you only have these witness statements, which means that that is what Emirates REIT is going to rely on and ask you questions about.
That's one more P5.
Sorry.
I think
Page
in total
171.
they are 7,
I'm
but
sorry,
I
Mr. Wu,
cannot
can you
argue.
correct me? Is there any more?
Page 171.
Yes, B5,
Mr.
is that
Lee.
right? Yes.
Mr. Lee, it's a matter of what you rely upon.
Oh, yes, that's right.
If you don't put the
yes.
witness statement in, then it's just not in evidence. Mr. Bull doesn't have to worry about it.
Yes, Your Honor,
This is the
that.
7th.
The 7th one, which is B5, yes.
And again, I confirm it's my name and my address.
Yes, we could go to the final signing page.
Yes, it's my signature. Correct.
Yes, and you likewise confirm that the contents in between the first and the last page are correct.
Yes, please. I believe they are all correct.
Yes, thank you very much.
You're welcome.
Yes, Your Honor, I have no questions in direct examination for the witness. Yes.
All right, thank you. Ms. Kakari.
Yes, please.
Mr. Bull, I now ask you some questions. Mr. Bull.
Thank you, Your Honor, and thank you, Ms. Kakari.
Thank you, Mr. Bull.
I am sorry to do this at the very beginning. We've just been through all of these witness statements, but
I know, no problem.
the issue of your address. What is your address? Because what you have declared on the documents is a street. There's no villa, house, or unit number.
Villa House. It's yes, it's a house, 21A Street in Almanara area, Villa 44.
Villa 44.
Maybe
Okay.
it's missing. Yeah, maybe it's missing.
It is, yeah.
I'm sorry. I was
And-
drafting actually. Sorry, may I complete my?
Sure.
Yes, I was drafting during the period that I was without counsel. So maybe in those witness statements there are some errors.
Right.
Before Mr. Lee takes over.
Understood. Yeah, so 44 Street, Villa
21A.
44 on Street 21A.
Yes, please.
Also, you say that you provide assistance to your husband's business. That
Yes.
business is ESC Aluminium Solutions. Is that correct?
Aluminium systems.
ESC Aluminium Systems. Okay.
Yes.
And your role there is the general manager. Is that correct?
Yes, but not anymore.
Until when?
It's been since COVID.
Okay. Is that the case in terms of your corporate registration? Because your LinkedIn profile, and I apologize for raising this, it hasn't been
No problem.
disclosed, but your LinkedIn profile refers to you as a general manager of ESC Aluminium Systems.
I'm not updating the social media, and I'm not very active in the social media. So this is the LinkedIn. I think I opened it like 4 or 5 years ago, 6 years ago, and but I don't follow Mr. Bull.
Okay.
Maybe I should update it and remove the role, but yes, not yet, because the business is not well at all, and even my husband is under bankruptcy procedures for his business.
Okay. I have no further questions, Your Honour.
All right, thank you. Was there anything arising out of that, Mr. Lee?
Your Honour, nothing in re-examination.
All right, well, thank you very much, Ms. Kakari.
Thank you all.
That completes your evidence. Thank you for your assistance. You're now free to come or go as you wish.
Thank you, Your Honour.
All right, well, that completes the evidence which you lead, does it, Mr. Lee?
Your Honour, yes, indeed, Your Honour. Yes.
Yes. All right. Well, now we come to closing submissions. I think ordinarily, Mr. Lee, you would go first. Or I see we've got the claimant going first and then having reply closing submissions. If that's what's been agreed, I'm content for that.
Whatever your preference is, I'm happy either way, Your Honour.
You go. Hopefully there won't be need for too much reply.
No, I think a very brief summary of the reply.
All right.
But we hope not to have to raise anything
Okay.
new. Okay, so we'll get straight into it.
Unless you wanted to take a short break, but it seems not very long since our last one.
I'm sorry, there's a pause because, Your Honour, I'm sorry. Do you want me to go first? If that is the case,
No, I'll get Mr. Bull to go first, and then
okay.
you, Mr. Lee, and then Mr. Bull can have a reply in relation to matters which he hasn't dealt with or reasonably anticipated.
Yes, as it pleases Your Honour.
Thank you,
Yes,
Your Honour.
Mr. Bull.
Your Honour, as you will recall, the claimant's primary position set forth in the skeleton arguments was that today's proceedings would not be necessary. It was our submission some weeks ago that the evidence before the court could only result in a favourable outcome for the claimant. It was a defendant's request to test the claimant's evidence, and I submit that such evidence have failed to swing the pendulum. Further submit to Your Honour that it remains abundantly clear, following the cross-examination of Mr. DeBar and Mr. Sharp, that the claimant took all reasonable steps to mitigate its loss. The question of the termination date is an imperfect one, but it is one that today's proceedings have not made any clearer. I submit, however, Your Honour, that the position put by the claimant in its skeleton arguments that the lease was terminated on or about the 10th of January 2020 is perhaps the most logical and plausible date based on the timing of communications between the parties, and I'll expand on this shortly. Your Honour, I'll start my closing by addressing the issue of mitigation, as I believe it is the most fundamental point of these proceedings. Article 1171 of the DIFC contract law, which can be seen at page 648 of the bundle, provides that the defendant is not liable for harm suffered by the claimant to the extent that the harm could have been reduced by the claimant taking reasonable steps. The court has the benefit of a well-trodden path of existing case law which provides clarity as to exactly what this term means. In the 1919 decision of Peizu Limited and Saunders at page 660 of the bundle, The Court of Appeal stated as follows: "It is plain that the question, what is reasonable for a person to do in mitigation of his damages, cannot be a question of law, but must be one of fact in the circumstances of each particular case." In the matter of Union Bank of India and Velocity Industries, a case helpfully quoted by my learned friend in the defendant's skeleton arguments, a copy of which is at page 732 of the bundle, the court quite plainly noted that the claimant must act reasonably to reduce the harm suffered, adding, "It is no more complicated than that." But most critically is the principle of mitigation when it's applied in a commercial context. In the 1875 decision of Dunkirk Colliery Company and Lever, the English Court of Appeal determined that the case of commercial claimants, such parties are not under any obligation to do anything otherwise than in the ordinary course of business. It is therefore the claimant's submission that its obligations following the termination of the lease with the defendant was no greater than simply carrying out its ordinary course of business. As noted today by Mr. DeBar, the claimant, a Sharia-compliant company, a Sharia-compliant real estate investment trust, publicly listed on the Dubai Nasdaq exchange. It exists to own, manage, and utilize real estate assets for its unit holders. The claimant, through the engagement of the management entity Equitativa, the current employer of Ross McLaughlin and Chloe Sharp, and the former employer of Mr. DeBar, spends every day looking to fulfill this duty to the claimant and to that end, the unit holders of the REIT. As such, the claimant's ordinary course of business is effectively limited to trying to utilize the real estate assets in a commercial manner. If it is found to have done this, I submit that it will have overcome the limitations on its entitlements that are imposed by Article 117 of the DIFC contract law. As the evidence has shown, the claimant has experts like Chloe Sharp working every day under the supervision and guidance, formerly by Mr. DeBar, now Mr. McLaughlin. It further engages with multiple premier leasing agents across Dubai who are each fighting to fill all of the available units in order for them to earn their commissions. I submit that the evidence shows on the balance of probabilities that it was operating in this way before it entered into the lease with the defendant, after it terminated the lease with the defendant, and continues to operate this way today. This is also a fact that the defendant was perfectly aware of. The defendant was aware of the Index Mall project in 2016 whilst it was under construction. The marketing and efforts by the claimant to pre-let the units of the mall reached the defendant, and she voluntarily entered into a lease of the premises, one that she restated in February of 2019. The defendant was not the only one to see the potential of the Index Mall as a retail premises before it had opened. 8 other tenants took the same gamble and entered into a lease of the premises before the mall had opened. These tenants had looked past the significant challenges that faced the site at the outset and made a bet that once connected to the Gate Avenue Mall, being the main pedestrian arterial to the entire DIFC, and described today by Mr. DeBar as the spinal cord of the DIFC, that the Index Mall would suit their business. But 8 tenants, 9 including the defendant, was not many. In fact, it was quite poor. As at 1st of November this year, the date of Ms. Sharp's witness statement, the Index Mall now houses 21 individual tenants, filling 30 of the 32 lettable spaces. But from 2016 to 2021, the number of tenants trading in the Index Mall never exceeded 8. Of the 32 lettable units, no more than 10 were ever occupied by businesses that were trading. This was despite evidence to show that close to 100 retailers were approached by the claimant and or its agents trying to find occupants for the mall over that period. As the court can see from the image at page 129 of the bundle, and I will just refer the court to that image if it has a moment. The Index Tower photographed here in this image, and the Index Mall, which it surrounds the tower at the bottom grey walled area, moving out towards a triangle shape behind the building, was effectively segregated from the rest of the DIFC until the western part of the Gate Avenue Mall was completed. Your Honour will see the construction works, which at this point have just been mapped out, but this building stands alone, essentially in the middle of the desert. It is submitted that whilst COVID-19 pandemic played some part in the difficulty of finding a replacement tenant, the primary reason why the unit situated within the mall was so difficult to let was the result of 1, surrounding construction works, 2, connecting infrastructure, particularly for pedestrian access, and 3, market forces required for this brand new part of the DIFC to become an established area that drew shoppers and diners to the area. These matters were all beyond the claimant's control. The Index Mall simply required time to generate footfall necessary for retailers to be interested in taking a space there. The evidence of Mr. DeBar reveals that the Index Mall was essentially desolate in November 2019, and this continued to be the case effectively until 2022 when Chavot opened. It is his evidence at paragraph 38 of his witness statement, page 48 of the bundle, confirmed by contemporaneous email sent in August 2020 that the tenants occupying the mall during this period were struggling. It is now the case that the Index Mall is flourishing. All but one space is occupied on the main retail level. The presence of successful chains, boutiques, and a government health facility now draws shoppers and diners to the Gate Avenue Mall and provides a hub for occupants of the Index Tower to meet and eat. This is something that has been achieved over time, and it is submitted that the evidence shows that this is just something the claimant could not have accelerated. The evidence also shows that the claimant took steps to advertise the mall, add signage for the mall, and procured an expert organisation to prepare a leasing strategy for the mall. All of this was over and above the efforts to approach and advertise the units to potential tenants. Ms. Sharp herself approached tenants in addition to the services of the 4 leasing agencies who together engaged with close to 100 potential tenants. Of all of these efforts, only 3 retailers expressed an interest in the premises. In July 2020, there was Yin Yang, a hair studio. In March 2021, there was Hair Creators. And in October 2021, Chavot, a hair salon that ultimately proceeded to lease the premises from the claimant on the 12th of December 2021. On each occasion, the claimant negotiated with these potential tenants, having to reduce its price per square foot each time to try and meet the lack of demand and beat the neighbouring competition. Such competition was exemplified by the situation with Hair Creators, who, despite being offered a rate that was effectively 33% cheaper than the defendant's rate for the same period, still opted to take a premises in the Gate Avenue Mall only some 50 metres away. I can refer the court to page 703 of the bundle to see a Google Maps image showing how close that premises is to the Index Mall. I appreciate, Your Honour, that this document has not been exhibited as evidence by any of the witnesses, but my learned friend consented to the inclusion of this page for our reference. On this document, it is highlighted Hair Creator Salon. The closest entry there is Miyabi Sushi DIFC, which is in the Gate Avenue Mall. Salam Smart Medical Fitness Center is in the Index Mall. Miyabi Sushi is in the Index Mall. These shops are right next to where Hair Creators ultimately ended up. Based on what my learned friend has set out in the defendant's skeleton arguments, I suspect he will shortly seek to advance his argument that the claimant's efforts to re-let the property were limited to these 3 occasions of one-on-one negotiations. He put this to Chloe Sharp today, who rightly noted that such was not inactivity on this point. Paragraph 13C of the defendant's skeleton arguments, page 803 of the bundle, the defendant has stated that for the first time Emirates REIT allegedly found a potential replacement tenant specifically for the premises was around 6 July 2020. The defendant then goes on to say in the skeleton arguments, this means that no action was taken by Emirates REIT for about 9 months after Mr. DeBar took the view that they should start finding a replacement tenant. Your Honour, I invite the court to dismiss such statement as intentionally misleading and plainly not correct. Such would only be true if tenants were lining up at the claimant's door with offers to lease the premises. This is simply a fallacy, and the evidence shows that this was not at all the case. The claimant's evidence for this trial on Quantum has sought to show that there was a non-stop effort to find a tenant. And when the slightest interest was shown by these 3 entities, all efforts were made to secure these tenants. The court only needs to look at page 112 of the bundle, where an email by Mr. DeBar to Ms. Sharp shows his jubilation to the news that the claimant might have secured Hair Creators as a tenant of the premises on the 7th of April 2021. The defendant has challenged the rates that were agreed with this replacement tenant of the premises. To this point, I rely on the details and mathematical calculations set out in the skeleton arguments, the claimant skeleton arguments, at pages 789 and 790 of the bundle, showing that on an apples-to-apples comparison, the rate agreed with the new tenant was not actually decreased by as much as it might appear on its face. This was due to the fact that a fit-out granted to the replacement tenant which did not have to be recovered over the term. It is also the case that the evidence of Ms. Sharp and Mr. DeBar showed a complete lack of demand and the need to reduce rates to meet the market. Finally, on the point of mitigation, we must look to the defendant's own evidence at page 607 of the bundle, paragraph 24, where she stated the following. From November 2019 onwards, the claimant was carrying on as though the lease had been terminated by looking to lease the premises to a new tenant. And I state again for emphasis, for Your Honour, from November 2019 onwards. Your Honour, there is no conflicting evidence here. From November 2019 onwards, the claimant was looking for a new tenant. This is evidence of both the claimant and the defendant. As I've noted previously, this is the exact conduct one would expect from the claimant in the ordinary course of business, and thus conduct that overcomes the limitations of Article 1171 of the DIFC contract law. I will now briefly turn to the termination date. In the defendant's skeleton arguments, the defendant has put forward 2 possible dates upon which my learned friend argues are open to the court to consider for the termination date. To put it frankly, neither can be explained by the evidence that is available. The defendant's first submission is that the lease was terminated on the 27th of October 2019. The email on 27 October by Mr. DeBar stated that the claimant was withholding its consent to the renewal of the fit-out permit pending, and I quote, full payment of all dues and reasonable assurance that you are in a position to honour the terms of the lease. Such language is fundamentally opposed to termination having been effected. The door was plainly left wide open for the defendant to comply and resume her works, all while leaving the lease on foot. Secondly, the defendant stated in a witness statement at page 586 of the bundle at paragraph 27, on 27 October 2019, the claimant emailed me to tell me that they had started legal action to terminate the lease. I understood that to mean that they would be terminating the lease without any further delay. But at that stage, I still believed that our relationship could be preserved. So I instructed lawyers to write to the claimant in November 2019 to explain that I wanted to find a constructive solution. It is clear from that statement the defendant never interpreted the email as a notice of termination. She has explicitly stated in her witness statement that she anticipated termination to follow, that makes it clear that termination had not been affected by that email. It was raised today by my learned friend that criminal proceedings in relation to the bounce checks were taken in October 2019. Clearly, such action did not cause the defendant to think that the lease had been terminated, based on what she said in her own witness statement. As we know, this was followed by the 10 November reply, which was sent by the defendant's lawyer at the time, and this provided a substantive response to the claimant's email and put forward a proposal for the claimant's consideration. On the basis of those communications between the parties and the defendant's own words on this point in her evidence, it is clear that no one ever interpreted the email as notice of termination, and any submission to the contrary is not supported by the evidence. The second submission by the defendant is that the lease was terminated on 10 November 2019. Again, there is no clear line of logic to that argument. A fundamental element for termination is notice to the party being terminated. It has been conceded in this case that such notice was affected by the party's conduct, and therefore it is not a question for this trial. The point, however, is that nothing to justify the defendant forming a belief that on the 10th of November, the very day she put forward a proposal to keep the lease on foot, that the claimant terminated the lease. I submit to the court that the most likely assumption by the defendant on 10 November was that a new period of continuance had commenced as she awaited the claimant's response to her lawyer's letter. It was understood that the claimant's response to that letter came on the 15th of December. My learned friend has today produced a document that reveals that such document was in fact sent earlier than that. The document shown on the screen showed that the defendant's lawyer forwarded it to the defendant on the 9th of December 2019, and he said that it was in fact sent to him on the 5th of December. As noted by Mr. DeBar, this information was welcomed by the claimant. Whatever the date was, 5 December, 9 December, the key fact here is that when it came to terminating the lease, the ball was in the claimant's court and the claimant's alone. The claimant had the option to accept the defendant's repudiation of the contract, not the other way around. If the claimant had communicated expressly that the contract was at an end before it issued the 15 December letter, then I submit that it was effectively impossible. Sorry, I'll start that again. If the claimant had not communicated expressly that the contract was at an end before it issued the 15 December letter, then I submit that it is effectively impossible for the defendant to have decided that it now deemed the lease as terminated due to the fact that the claimant had not responded to her letter in time. Even though the claimant was testing the market, as we know the defendant's evidence, it was looking for a new tenant from November onwards, in order to see if it could line up a potential replacement tenant for when it did pull the trigger, nothing had been done to bring the lease to an end. And the 15 December letter affirms that the lease, in the eyes of the claimant, was still alive and on foot when it sent that letter. Your Honour, we have made a submission in our skeleton arguments that the most appropriate date as to when the lease was terminated is on or about 10 January 2020. Whilst those submissions are imperfect, in light of the facts, we believe that the date proposed is the most logical and plausible date which the termination of the lease was effected. I do appreciate, Your Honour, that the optics of this case are not ideal and that the landlord may appear as if he's coming down hard on a tenant who just tried to start a business and got in over her head. I put it to the court that the defendant's evidence has been intentionally crafted this way. For what it's worth, I ask the court to veer away from any such inclination. The defendant has consistently described herself as a full-time mother, but she was in fact the general manager of ESC Aluminium Solutions. The website of this company Aluminium Systems, I'm sorry. The website of this company shows that it is a significant construction firm that has carried out projects throughout the UAE, Pakistan, and Tanzania. It is not a small enterprise. I further note the court's understanding that the title General Manager is effectively the primary representative. The person and the role is specifically named in the company license and is a role of significance somewhat akin to a company director of an Australian corporate entity. The defendant has also introduced further evidence relating to her successful efforts to thwart the claimant from enforcing payments made by post-dated checks that had been issued through her onshore Dubai company, VKA Ladies Beauty Lounge LLC. The defendant, as general manager of VKA Beauty Lounge LLC, with the engagement of international law firm Baker & McKenzie, appealed that decision of the Dubai court, which had issued an enforcement order against the payment of these instruments. Her argument was generally that the Dubai court did not have jurisdiction to make such orders. Such argument was successful in the Dubai Court of Appeal. This is not an endeavor done by someone who is naive and in over her head. This is the conduct of someone who has the resources and vigor to fight. Furthermore, let us not forget, the defendant directed the claimant to pay her fit-out contractor 1 million dirhams. Of that amount, a sum of 766,000 was paid to them. And of the sum paid, her contractor admitted to funneling her a sum of 230,000 dirhams, funneling a sum of 230,000 dirhams to the defendant's other business, VKA Ladies Beauty Lounge LLC. And secondly, the fit-out contract works that were done were of almost no value. I refer the court to page 447 of the bundle as a reminder to the court of what a dismal effort was done on the site over a period of nearly 11 months. The money paid by the claimant at the direction of the defendant was never recovered. Instead, the defendant undertook expensive legal proceedings through the Dubai Court of Appeal to thwart payment of the checks that she had submitted for payments that she owed. It is also the case that in the course of these proceedings, the defendant commenced a counterclaim against the claimant for an undisclosed sum on the basis that it was the claimant who defaulted under the lease. The fact that we are here today comes after a series of many surprises and an unyielding fight brought by the defendant. As I have just noted, evidence countering the arguments that are now being pushed by the defendant in her own skeleton arguments are directly contradicted by her own evidence given in this case. As such, it brings me great pleasure that we are now at the end of this case, with moments away from it being concluded, and particularly where the evidence and law aligns in favour of the claimant. Your Honour, on behalf of the claimant myself, we thank you for your time and attention in this matter. I trust if the court has any questions, feel free to ask. And Your Honour, I yield my time. Thank you very much. You're on mute, Your Honour.
No, I was saying, thank you, Mr. Bull. That's quite clear. I have no further questions. Thank you.
Thank you, Your Honour.
Mr. Lee. Mr. Lee, I think you're on mute.
Thank you, Your Honour. This court is being asked to decide only 3 issues in today's proceedings. Firstly, whether the claimant has a duty to mitigate and whether the claimant has discharged it. Secondly, when the lease was terminated. And thirdly, the quantum of damages that Emirates REIT is entitled to. Before I make my submissions on Ms. Kakari's positive case on each of these 3 issues and how the evidence given today has advanced her case, I want to make 3 general observations about Emirates REIT's case. Firstly, in the final analysis, Emirates REIT's case is a case in search of facts and evidence rather than one based on facts and evidence and I will explain why in a short while. Secondly, Emirates REIT has shown a clear willingness to try routes and arguments, whether they are open to it or not, just to be in pocket for the money that, in its subjective belief, it is entitled to. And the third, which just arises, is because Mr. Bull has not cross-examined my witness and put a contrary case to her, so the put rule has not really been observed. Now, the first point, the Emirates REIT is running a case in search of facts and evidence rather than the other way around. This can be seen on how it's changed its case both on termination date and mitigation. On termination date, which we start off with first, in the particulars of claim, it did not specify a termination date expressly, except as to suggest that termination occurred on registration with the DIFC authorities in late 2021. And after we pointed out the inconsistencies between such a position and the evidence, much of the evidence coming from Emirates REIT itself, my learned friend at the same hearing then conceded fairly that the date was sometime by November 2019 or December 2019. Your Honor can review the YouTube video of the immediate judgment application hearing at the 1 hour 54 minute 59 second mark through to the 1 hour 55 minute 56 second mark. After Emirates REIT was given the chance to file further evidence on mitigation, suddenly the termination date became 10th of January 2020, a date mentioned for the very first time with no documentary basis whatsoever, seemingly just for purposes of this trial. I do not like to say this, but Emirates REIT is like Alice lost in Wonderland, her wonderland of termination dates. In order to maintain its delusion on termination dates, Emirates REIT downplays its email of 27 October 2019, which was in written form, copied to various people showing seriousness of intent. It also requires us to suspend our intellect and disregard their pleaded case that as of 10th November 2019, the lease had been terminated by the conduct of both parties. On mitigation, Emirates REIT's case is equally hopeless in its search of facts and evidence. We first have there Mr. Daniel Ross McLaughlin say at paragraph 49 of his witness statement, quote, "My understanding as an expert in the retail leasing industry is that during the COVID-19 pandemic, the claimant was unable to lease any of its retail units in the mall, and that even after restrictions lifted, while all efforts were made to find tenants for the mall, there was a lot of hesitancy from potential tenants. Occupancy only started to improve in 2022-2023, unquote. The sequence in which Mr. McLaughlin says it in my submission is that all efforts were made after restrictions were lifted and not before. He does not go as far as to say when restrictions were lifted, but surely it cannot be before the second half of 2020. In fact, from the text of what he says, because he does not specify what restrictions he had in mind, he can equally mean the latest restrictions as well as the earliest restrictions. Now, when realizing that it could not recover almost all the 4 million dirhams that it is seeking because it had not established its fulfillment of the duty of mitigation, suddenly Emirates REIT paints a picture that it had all along been hard at work trying to find a replacement tenant. As covered earlier, they could not adduce evidence to substantiate their bare allegation that in November 2019, they instructed Tizen to look for a replacement tenant. The earliest evidence is that for the first prospective tenants, that Heather, which came on the scene in July 2020, half a year after their own termination date of 10th January 2020. And they have no evidence linking that to earlier efforts. In fact, they have no evidence of earlier efforts. And Your Honor will note that while both Mr. Diba and my learned friend takes the position that there were 3 prospective tenants, I'm going further and saying that even before that first one, which they said is Yin Yang, I'm giving them the benefit of the doubt and saying that that Heather was the first one that they approached. And even on that basis, there's a long time lapse. They suggest, they being Emirates REIT, suggest that they have approached 4 letting agents, IRE Partners, Kaizen, CB Richard Ellis, H&H, to let out the units, including Ms. Kakari's units, but their own instructions to at least one letting agent, H&H, contain an express mention that Ms. Kakari's 3 units were, quote, currently leased, unquote, thereby excluding Ms. Kakari's 3 units from these efforts. And they deny that similar exclusionary instructions were given to the other 3 letting agents, but they have not produced evidence of such instructions for this court to be able to verify that. Neither have they told these 3 other letting agents to give evidence. Mr. Diba has confirmed that at least for 1 or 2, he initiated the relationship. So he could easily have tried to call them, but there was no indication. And furthermore, these letting agents stood to gain commissions from the first-year lease. So they had every business incentive to come along and give evidence if Emirates REIT were to ask them, notwithstanding that there's no direct hierarchy between them requiring, for example, an employee to give evidence on behalf of an employer. Now, furthermore, Mr. Diba also mentions in his witness statement that he came up with marketing strategies to promote the mall. But again, there is no evidence of follow-up on these strategies. My second point, that Emirates REIT is willing to try every route and every argument, whether open to it or not, to recover monies it subjectively believes it is entitled to. Your Honour will note that it commenced suit before the Municipal Courts of Dubai, originally for the unpaid rent, and that's the evidence that we were looking earlier. Even though on its own standard form lease, Emirates REIT itself specifies that the DIFC courts have exclusive jurisdiction. I gave Mr. Diba a chance to say something in Emirates' defense, and essentially, I'm sorry, I did not, this is in my text, I take back what I last said. I did not give Mr. Diba a chance to say that because I had no time. I'm reading from my prepared speaking notes and I was going to fill in what Mr. Diba said, but of course, I never asked him that question. Your Honour will also note that when Emirates REIT commenced action in the Municipal Dubai courts, which was wrong, of course, it sought to claim a far lower amount than this 4 million it is now claiming. Another example of its unprincipled approach to claiming money if we need one. Just to be clear, given that DIFC written law, just as it does not have a tort of malicious prosecution, as we went through at the immediate judgment hearing, neither does DIFC written law have a doctrine of unconscionability. So we are raising this not as a substantive defense, but as a prejudice point. We are not asking Your Honour to make any findings on unconscionability as a legal matter. We therefore did not cite case law such as Amadio, which in the common law world is strong authority for the doctrine of unconscionability in support of our statement. But even though we make no submissions on unconscionability as a term of art, what they did remains unconscionable at a commercial level and a human level. Now, turning now to my substantive submissions on the 3 issues, Your Honour.
Mr. Lee, can I ask
Yes.
you just to pause for a moment? I'm just going to close my camera whilst I go and close a window. Just bear with me for a minute, please.
Certainly, Your Honour.
Yes, please carry on, Mr. Lee.
Thank you, Your Honour. Yes, I mentioned earlier, I'm now turning to my submissions on the 3 issues that this court is being asked to decide today. On the first issue, we say that Emirates REIT had a duty to mitigate, which is common ground between parties. And we say further, and this is disputed, that Emirates REIT failed in its duty of mitigation. Now, Emirates REIT certainly cannot dispute the duty, there's a duty of mitigation because the DIFC law sees this duty as important enough to provide for in two separate places. Article 16.1 of the DIFC Law of Damages and Remedies and Article 1171 of the DIFC Contracts Law. This essentially, Your Honor, are mirror provisions, except that the one uses the word harm and the other uses the word loss. We say further that because the Emirates REIT had failed in its duty to mitigate because it breached the temporal requirements of immediacy of mitigation, and because it failed to establish reasonableness of quantum of rent for its replacement of tenants. Firstly, Your Honor, immediacy of mitigation. The claimant has cited case law going back to the early 1900s, but failed to appreciate that the black letter law of the DIFC contains a temporal requirement within the duty of mitigation that has not been fulfilled. Article 16 of the Law of Damages, according, and Your Honor, this is in my skeleton argument. What I'm going to say next is in my skeleton argument. So Your Honor can refer to that. I'm just outlining it very briefly here. Does Your Honor want to wait until you get to the skeleton arguments, or would Your Honor like me to carry on? Your Honor, you're muted.
Yes, just carry on, please, Mr. Lee.
Yes. Article 16 of the Law of Damages, according to the laws of the DIFC, which is a commentary of the laws of the DIFC, follows the position in English law, and house breeze is stated to provide details of a claimant's duty to mitigate loss. We have put in the relevant extract from house breeze, which in turn provides that there is, quote, an immediate duty to mitigate, unquote, where, quote, a claimant accepts the defendant's anticipatory repudiation, thus putting an end to the contract before the time fixed for performance, unquote. Neither in Emirates REIT's skeleton, nor in today's oral closing, has this express immediacy requirement ever been brought to this court's attention. And neither has it been grappled with. Mr. Diba can point to no evidence of any efforts made to let out Ms. Kakari's units before July 2020, when that hello first came on the scene. This is 6 months after his own termination date of 10th January 2020. It obviously fills the requirement.
Mr. Lee,
yes,
that's not the evidence. The evidence is that they were making efforts to rent out the units.
Yes.
The July date was the date when there was somebody who actually inspected them. But
yes,
that's not the same thing as saying that there were no efforts to lease before then.
Your Honor is entirely right to say that they also added two other aspects. First, the 4 letting agents that they approached. But if you were to read Mr. Diba's evidence, he does not specify when these 4 letting agents were approached. There is, as we have gone through, no correspondence along the lines of H and H. I'm sorry, let me qualify what I just said. For 3 of these, there was no evidence of dates. For H and H, there was evidence of date. November 2020 and October 2020. October 2020 was when they prepared the proposal. So we do have that one date, and this October 2020 date is 9 months after their own termination date of 10th of January. Now, with regard to the other 3, there is no evidence whatsoever. We only have Mr. Diba's say-so. And these letting agents were not assisted by the fact that they did not come to give evidence as to when they were approached. Next point. I made the point earlier that the only thing that could save Emirates REIT's case is that if there were evidence of Mr. Diba's bare allegations that he did actually instruct Kaizen. I'm sorry, Your Honor, you have gone off the screen. Shall I wait? Your Honor, you're on mute and your screen is not showing you. Yes, you're on mute, Your Honor. You're muted, Your Honor. I'm sorry, Your Honor, you're muted.
No, we're back in business.
Now we're back in business, yes. Let me just carry on from where I think you dropped off. I said that Mr. Deba can point to no evidence of, sorry, I said that I made the point earlier that the only thing that could save Emirates REIT's case is that if there were evidence of Mr. Deba's bare allegation that he instructed Kaizen in November 2019 to look for a replacement tenant. There is no evidence tendered by Emirates REIT in this regard, and Emirates REIT also did not procure testimony from Kaizen in this regard. I should also add that if indeed there was such efforts before July 2020, at the very least, there would have been internal updates, at least, as on leasing efforts and status. None of this was ever adduced as evidence. And when I tried to ask Mr. Deba about that, he went on and on about the importance of amicability and did not answer my question. Therefore, it is my submission that this court should draw an adverse inference based on the lack of evidence and find that there were no efforts made by Emirates REIT in November 2019 to get Kaizen to find a replacement tenant. Now, I now turn to the reasonableness of quantum of rent sought from replacement tenants. Emirates REIT did not give evidence of comparative market rental. That was a point I went through at some length, which would be necessary for assessing reasonableness of quantum of rent. For Chevaux, we have a redacted schedule of rents, and even just looking at the unredacted portions, the initial rent was at a shocking 2/3 haircut from the rent that was charged to Ms. Kakari. The only way to justify such a rent as being reasonable was to show market rent, actual market rent. And that is an evidentiary duty owed by Emirates REIT to prove its case on mitigation, because Emirates REIT is a party that owes the duty of mitigation, and only it knows what it did to discharge that duty. And Emirates REIT failed to discharge this evidentiary burden. Furthermore, if Emirates REIT were to truly apply its mind to securing a reasonable quantum, Emirates REIT could have had tried to market Ms. Kakari's 3 units as individual units in a 2-1 permutation, which would have allowed it to at least increase its prospects of recovering some rental. Of course, not 100 cents on the dollar, but it's better than zero. It is not rocket science to come to the conclusion that a single 2,600 square foot unit may not be as attractive to certain segments of the market as 3 separate units or a 2-1 permutation. And not all 3 units need to have been let out. Even if 1 or 2 single units had been let out, it would have gone a long way towards mitigation of loss. There is no evidence of Emirates REIT having done so. And neither, I asked Ms. Sharp about this question, and she pointed to none. On these alone, when I say these, I mean, number 1, the failure to take immediate steps to mitigate, and number 2, the failure to prove reasonable quantum of rent sought from the replacement tenants. We can say with confidence that Emirates REIT failed to discharge its duty of mitigation. Even if we take the claimant's case on termination, even if we were to take the 10th January 2020 date as a date of termination, rather than any earlier date, then Emirates REIT should have taken steps to mitigate on or shortly after that date. But as we have said earlier, there is no evidence of them doing so, apart from their own bare say-so. There was no evidence of efforts from January until July 2020, when that hair first came on the scene. And Your Honor, for the 4 letting agents, we only have evidence on H&H, which came on the scene in October 2020. There is no evidence of that hair's interest being the manifestation of efforts that started way back before July 2020. If it were indeed a manifestation, surely there would have been some evidence. But there is none, not even written testimony. Such lead-up efforts must have been made on or shortly after 10th January 2020, adopting their own termination date. No evidence of that. Therefore, Your Honor, as my submission that an adverse inference in the interest of justice has to be made against Emirates REIT in this regard. And a finding made that efforts were made only from July 2020, which is more than half a year after Emirates REIT's own termination date of 10th January 2020. Emirates REIT is, of course, aware of its own evidentiary difficulties. Best answer to that, as it comes across from the witness statements, is that even if they did not specifically market Mr. Kakari's units, efforts were made towards the wider mall in general, and these efforts were continuous one. Again, Your Honor, I cannot overstress this point. There's simply no evidence of these wider efforts apart from the H&H correspondence. There is no evidence for CB Richard Ellis, Kaizen, IRE partners, apart from Mr. Diba's own say-so. And I ask Your Honor to take special notes of 2 points in particular. First, that none of these letting agents, that none of these letting agents were called to give evidence, when easily they could well have been called to do so. Second, with regard to H&H, the evidence shows very clearly that it was more likely than not that Ms. Kakari's 3 units were excluded from the scope of instruction to market by mentioning that they were, quote, currently leased, unquote. I asked Mr. Diba about this, and again, he gave me a long rambling answer without coming to the point to satisfy how it is that when the instructing party says something is currently leased, the vendor taking the instructions should assume otherwise. It is open to this court to draw the inference that even if the other 3 had actually been engaged, similar instructions were given to them. And I say this because the marketing collateral produced in July 2020 by vendors that they engaged stated VK Beauty to be coming soon. Your Honor, I will go now to page, I will give you the page reference.
Yes.
Yes, Your Honor, please bear with me for a short while I go to Mr. Diba's evidence to give you that. Your Honor, if you go to V2, page 81, page 81 is Your Honor on that page of B2, page 81. Thank you, Your Honor. Right at the bottom, and that is, it says page 30. That is page 30 on Mr. Diba's original bundle of exhibits. And he says that those are designs that he procured for marketing in July 2020. If Your Honor were to look at the graphic at the bottom, do you see keep an eye out as more retailers open? Your Honor is muted, I'm sorry.
Sorry, where should I be looking?
You see a rather a page full of pictures, and
yes,
right at the bottom, yes, it says keep an eye. There's a table which is relatively blank. It says keep an eye out as small retailers open. Do you see that?
Yes.
Yes. And right within that box is VK Beauty. So even as of July 2020, they were giving instructions on the basis that VK Beauty, which is of course our client, was still a tenant. So why should anyone in their right minds market Ms. Kakari's units if they were given such instructions? Now, of course, Your Honor, in fairness, I have to say that the ultimate tenant, Chevaux, was procured by H&H. So obviously, separate instructions must have been given somewhere down the line after they've precluded Ms. Kakari's units from the scope of instructions. But Your Honor, as I've said earlier, it is entirely open to Your Honor to find that similar instructions were given to the 3 other letting agents. They simply did not produce any evidence to the contrary. Yes. And the next I, of course, note that Mr. Diba naturally refused to admit that the instructions to these letting agents contained similar instructions, leading the letting agents to the same conclusion that there was no need to market Ms. Kakari's units. But given that the duty was on Emirates REIT to disclose those documents, and Emirates REIT did not, I ask Your Honor to draw the adverse inferences that I am seeking. Finally, the way that Emirates REIT went about trying to convert that hair, though, in Yang, hair creators, as shown on the evidence, was almost non-existent. These were the 3 prospective tenants that came onto the scene before Chevron ultimately took it on. No evidence of how the negotiation took place and no evidence of how efforts to convert were made. With Yin Yang in particular, it becomes almost farcical when we consider how the evidence shows that the only plausible reason Yin Yang walked away from the table is that Yin Yang wanted Year 5 rent to be 200 dirhams per square foot, but Emirates REIT wanted 210 dirhams per square foot. And after that, their own documents show that they were waiting for Yin Yang to come back with a counter offer, presumably on price, but they never bothered to follow up to secure the counter offer. At the very least, there is no evidence of them following up to secure the counter offer. Now I move on, Your Honor, to the termination date. The fatal flaws with the 10th January 2020 date are, well, there's a few key factors. First factor, it was never part of Emirates REIT's case until just before this trial, when they realized that they stood to recover only rental up to termination date because of their sparse mitigation efforts. Second factor, if these were a real date, it must be in the particulars of claim or subsequent pleadings, given that termination was not an event waiting to crystallize, such that no one can, when drafting the pleadings, set it out yet. It was a discrete event that happened before the case commenced. Termination would be a discrete event that would have occurred before the case commenced. And given that the claim was for all rent under the lease based on breach, termination must have occurred in order for this very case to have been brought. 27th October 2019, Your Honor, conversely, is the date we say is the cleanest termination date to support based on the facts. There was an express indication of termination in the email of that date, which is Mr. Diba's email of 27th October 2019. The IFC law allows for notice to suffice as termination, as we have covered in our skeleton arguments. By 27th October 2019, Emirates REIT had commenced criminal proceedings, and the date we have in the documents is 22nd October 2019. Now, a party that commences criminal proceedings must be intent on terminating a commercial relationship. Even if Your Honor is not with me, that the email mentioning passing over the matter to legal with a view to termination has an effect, surely commencing criminal action, which is a surest way of burning bridges, must have that effect. The challenge that Emirates REIT tries to put up is to say that the 15th December letter countermanded the termination. So they are saying their later missive countermanded the earlier missive. Your Honor, I tried to run that argument once in the Singapore High Court and I was roundly corrected. And in my case, I was saying that because the CEO of my client said that we will pay these invoices in the morning, and if in the afternoon then said, sorry, we are not, and we'll take this up as part of a broader discussion. So there was no unequivocal admission as to the debt, and the afternoon communication had the effect of countermanding the morning communication, and I was given short shrift for that. Of course, Your Honor, it's a question of fact, but Your Honor, you look at the time lapse between the 27th October email and the 15th December email letter, surely the countermanding could not have been effective, or at any rate, not as effective as Emirates REIT thinks it is. The best characterization that can be put on the 15th December letter is to say that it affords a grace period. That's the best characterization, not a countermanding, but a grace period. But Your Honor, even that runs into problems because grace periods can only be given when a contract is still in subsistence, when it's still on foot. Giving of a grace period on a terminated contract is a contradiction in terms. And if Your Honor, for any reason, still has difficulty with 27th October 2019 as a termination date, then we say that Your Honor can find comfort in the fact that on the alternative date of 10th November 2019, that is backed by no less than Emirates REIT's own pleadings and re-entry. It is backed by their pleadings because of paragraph 226 of their own amended defense, in particular subparagraph F and H. And let me just go to that and give you the reference at the same time. So that would be at tab A3. Yes, sorry. Oh, sorry. Your Honor, sorry, it's a, let me just, no, it is, it's the part where, I'm sorry, Your Honor, it is not A3, it is A4. Yes, A4.
You know what page that is?
Yes, it is at page 36, Your Honor. Is Your Honor at page 36?
Yes, I have it. Thank you.
Thank you. Your Honor, if you were to go to subparagraph H, the lease was effectively terminated by the conduct of both parties. And what's the time frame for that happening? If you go two subparagraphs up at F, it's after 10th November 2019. The defendant made no effort to remedy the defaults it had been notified of. And we say there is no other construction than to say that the effective termination of the lease by parties' conduct could only be as of 10th November 2019. So this is on Emirates REIT's own pleading. Re-entry. That's subparagraph G on the same page. The language is redolent of re-entry. And when I asked Mr. Diba, again, he gave me a long roundabout answer, but did not deny that there was re-entry on that date. In fact, he was giving colorful explanations of what he saw on the scene. So all the more likely there was re-entry on that date, either by himself or his own agents or his employees. I do note in fairness that he says that as a senior person, he would not necessarily do this thing himself. And in any case, it must be the natural interpretation of subparagraph G. How would Emirates REIT know that nothing of value had been left by the defendant or the fit-out contractor unless and until they had re-entered? And Your Honor, in the...
But yes, going on to the premises is not the same thing as re-entering?
Going on to the premises is not as such, but on their own... What happened, Your Honor, is that these premises were locked. It is common ground that Ms. Kakari never started operations. It is not a unit where Ms. Kakari was running business from, such that they could go and inspect. There's a dispute over whether fit-out works were completed even by that date. So this was a closed-up unit. And Your Honor, why would anyone make paid stress that nothing of value had been left by the defendant? Simply because re-entry carries its risks of the tenant turning around and saying, how dare you enter and now my things are missing, I'm going to hold you liable. So, for example, practice in certain jurisdictions is that if you want to, if a landlord wants to re-enter, they would get the bailiff to come along. That is the fear that people have. So the language, that's why I say the language is redolent of re-entry. And even if your honor is not with me, that that re-entry is established, we have the language of that own pleading saying that the lease had effectively been terminated by the conduct of both parties. So I have two alternative grounds, Your Honor. May I carry on, Your Honor? Or is there any further question in this regard that I can assist you with? Your Honor is muted. Sorry, Your Honor is still muted. I'm sorry, Your Honor is
Your Honor was just going for pages and.
I see. So does Your Honor want to me to stay on this point, or does Your Honor want me to move on?
No, continue on, please.
Thank you. Now, so these are two alternative grounds. And let me make one last point about re-entry. If Your Honor is with me after consideration, that more likely than not there is re-entry. I had in my skeleton arguments for the immediate judgment application, as well as at my oral submissions then, shown how DIFC law, in particular, Article 55(4) of the DIFC real property law, ties in re-entry with termination. Perhaps, Your Honor, let me just go through that reference. Please bear with me a while. Let me just go to the bundle for you on that point. Sorry, G3. Yes, please go to tab G3, and let me get you the specific page. Page 709, Your Honor, on section tab G3. Is Your Honor at that page? Yes. So it says, page 709. Yes. Shall I proceed to read that text? Yes. It says, in addition to the powers under paragraph 1, the lessor has the implied power to re-enter the lease premises and terminate the lease in the following circumstances. And it states two of these circumstances. And there is, we do fulfill the invocation of Article 55(4). Now, what is interesting, Your Honor, is to see that the implied power to re-enter the lease premises and terminate the lease is in the conjunctive. And the word power is in the singular rather than the plural. This mirrors the common law position that once re-entry takes place, forfeiture of the lease or termination of the lease takes place. So Your Honor has every basis, if and only if Your Honor is with me, that re-entry had taken place on the 10th of, by the 10th of November 2019, then Your Honor has every basis to find, based on Article 55(4), that termination had taken place on that date. I now move on to my next point. So in sum, I say 10th of January 2020 is a fictitious termination date put up by the claimant so that he can willy-nilly recover slightly more damages. And this date is to be dismissed outright. 27th October 2019 is a cleaner's date, amply supported by the facts, by the law, and by the evidence. And alternatively, 10th November 2019 is a plausible alternative, supported by the claimant's own pleadings, and if Your Honor is with me, the fact of re-entry. On quantum, which is the final issue, the third and final issue, we have set out in our skeleton the numbers for damages if 27th October or 10th of November 2019 are found as the termination dates, and that's at page K2, page 810. into page 810. Is Your Honor on that? Yes. So because they have set out, and it's best presented in visual written form rather than orally, I do not propose to expound on that orally. Just for completeness and without admission that 10th January 2020 is the termination date, I do have some numbers, and if Your Honor were to wish to direct, I could send over similar presentation and calculations subsequently. I have that as a document in front of me. Yes. And if the total quantum of both sums due and payable under the lease and as an interest accrued up to 10th January 2020 is in dirhams terms 197,311.18. Yes. So that is the number that I have, and if Your Honor were to require me to submit that, I'm very happy to submit that. Now, let me just check with my co-counsel whether there is anything that I may have missed out on. Yes. Your Honor, as far as my substantive submissions are concerned, I have come to the end. And unless Your Honor has any further questions, that's it. The only thing I have is housekeeping, which is firstly, I showed the this email from my client's lawyers earlier, and I said that if Your Honor would wish for me to abuse it as part of the record, Your Honor does not require that. Your Honor is muted.
I just say I think it's been dealt with. Thank you.
Yes, I note that Mr. Bull has also attempted to grapple with that as well. That's another.
Okay.
Yes, and my second and final housekeeping, if you like, point is, I suppose Your Honor does not require written closing submissions after hearing. Yes, thank you.
All right. Thank you very much, Mr. Lee. Mr. Bull.
Yes. Mr. Bull, you're muted.
Thank you, Your Honour. Of course, it goes without saying, I disagree with just about everything that's been said, but I will rely on my skeleton arguments and my statements made previously. Just touch on a couple of points very briefly. One is the continuous mention of that hair, though. There's that notation by REEP that that hair, though, did an inspection. This is just a notation. This, as far as I'm aware, this led to nothing. It's only yin yang that got to the point where it was serious enough where the parties actually drafted the offer or lease proposal document. So what happened with that hair, though, is probably not inconsistent, which other tenants may have or other entities may have expressed or done an inspection and been recorded on these other documents, which unfortunately we just haven't been able to track down, as Ms. Sharp had noted. There's the reference on page 97 of the bundle to H&H's reference to VK Beauty occupying the premises. This document is dated October 2020, but the simple fact is the defendant herself has said that the claimant commenced efforts to try and relet the property in November of 2019. And it's uncontroversial that Yin Yang was issued a lease proposal in July, which is months before H&H. This is simply a transposition error by a new agent coming on board. My learned friend has also raised issues with regard to the property being split into single units. This is pure speculation. And it also ignores the fact that there were 20 vacant units in the mall. Of the 30 units that were there were 20 individual vacant units. And splitting this one into 3 units is unlikely, or there is no evidence at all that it would have changed the situation at all. This is a really key point. We've seen today Mr. Debar and Ms. Sharp express clear statements that this was a key asset of Emirates REIT, and they pushed to get these units let. But it is not until Chavot was leased that a single unit in the entire mall was leased. Now, that was not as a preference to try and get this one let first, as much as my learned friend has pushed today with Ms. Sharp to say whether or not there was any specific push for this unit. This was our tenant, our client doing, or the claimant, doing its ordinary course of business, trying to lease out this mall. And that came, fortunately, for the defendant and for everyone involved with the letting of this unit, which started a snowball effect, really, and it's now a buzzing atmosphere down there. My learned friend has talked about the re-entry. This is all done without reference to the terms of the lease. As we know, the situation at that stage was that the tenant was still in the fit-out phase. Our client had rights under the lease to deny the tenant access to the premises until it got its works permit back in place, which had been prevented on the 27th of October due to outstanding monies and the defaults that had occurred. And our client had the right to access the premises, but there's been no reference to the lease in making this argument. And such, I think that should be dismissed and ignored, because the landlord going down and seeing the state of his unit and making a decision as to whether or not it's time to terminate this tenant, or whether or not she's close and 1 week away from completion, is really the right of the landlord to see what's going on his site, and he had those rights under the lease. Finally, there's been numerous references to page 36 of the bundle, and particularly paragraphs G and H. They are standalone statements. There is no dates noted on those statements. Nothing ties those statements to 10 November. It is just that it follows the statement that where the 10 November date was noted, but nothing ties or suggests, I would say, that either of these actions occurred on the 10th of November. Your Honour, I have nothing further to add, and only that we do request the right to make submissions on costs at the end of these proceedings.
All right, well, thank you. I will reserve my decision and consider costs later. I thank you for your assistance, and I thank the court staff for their forbearance. As I say, I'll reserve, and that concludes today's hearing. Thank you very much.
Thank you, Your Honour, and thank you to the court.